committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. Pursuant to Committee Rule 5 and Rule 11, House Rule 11, the chair may postpone further proceedings today on the question of approving any measure or matter, or adopting an amendment of which a recorded vote for the yeas and nays are ordered. Now, pursuant to notice, I call up a report containing a contempt resolution.
Mr. Chairman, I have a point of order.
May I finish? May I please finish? Thank you. Now, pursuant to notice, I call up a report containing a contempt resolution related to the 2020 census. Clerk will report the report, which has been distributed in advance.
Mr. Chairman, I have a point of order.
The gentleman is not recognized.
Well, the point of order, actually, from a parliamentary standpoint, is a privileged motion, so I have a point of order, Mr. Chairman.
What is your point of order?
My point of order is that Rule 2F of the committee rules have been violated, and the chairman has received a letter which would outline that that particular rule requires a 3-day notice, Mr. Chairman, and because the notice was put out on June 10th at 5:48, this committee's rules have been violated. Now, the chairman may be able to overrule this point of order, but I would like to clarify that if indeed this committee overrules this point of order, then indeed it would be subject to litigation by House counsel. You will require the Department of Justice to file a brief. It will be litigated because indeed this is violating the House rules that everyone here agreed to.
Thank you very much. Thank you. I'd like to address the letter the ranking member sent last night, raising a new technical argument about the committee's rule on circulating the memo for today's business meeting. Basically, he argues that the memo should have been sent last Friday instead of this past Monday. I sent a letter back to him this morning explaining my position, and I can summarize it here. In the last Congress, the committee rules used to require a memo 72 hours before a business meeting. In January, we on this committee unanimously adopted rules that changed that requirement to 3 days. As I stated when we made that change, our purpose was to make sure that our committee rules matched the House rules. The timing of our committee rule was drawn from the House rule on noticing business meetings. That rule provides that a markup cannot occur, and I quote, earlier than the 3rd calendar day before it is noticed. The House parliamentarian has interpreted this rule as including the day the notice is sent and the day the business meeting occurs. Committee staff confirmed this interpretation with the parliamentarian again yesterday. So in other words, we needed to send a notice on Monday for a markup today.
Mr. Chairman.
May I finish, please? Sure. That is exactly what we did here. That is how we have been interpreting our rules for the past 6 months. And that is now how I interpret the rule today. With that said, I understand if this rule change caused some confusion. There are slight differences in the wording of our rule and the House rule. The problem with the ranking member's interpretation is that the committee could send a memo out to members before we even notice a markup. I do not think that process makes sense, and that is not the intent of our rule. I've stated my interpretation of our rule. However, as I wrote in my letter to the ranking member this morning, if he still feels that there is any confusion whatsoever, because all of this has all been in good faith, I'd be open to further discussions to clarify or to amend our memo rule in the future. With that,
Mr. Chairman, so let me follow up on my point of order. And while I appreciate where the staff is giving you clarity from the parliamentarian in the House, this committee purposefully, with your words, took different language. And I'll read: at least 3 calendar days, excluding Saturdays, Sundays, and legal holidays, before each meeting or hearing. In your words, Mr. Chairman, the minority wanted to give more advance notice for hearing memos, so we did that. That was a quote from you. And we purposefully, in this committee, because of the importance of this committee, made a difference between the House rules. And so I would suggest respectfully, that this particular rule is indeed intentionally different. And by that, we're opening ourselves up to litigation on this particular issue, where just postponing by 1 day would have made us in compliance. And I respectfully yield back.
I have explained my interpretation, and I've offered to work with the ranking member going forward to resolve any remaining confusion. I'd point out that our rule also includes a separate independent provision allowing the committee to go forward in unusual circumstances. The ranking member's letter last night, for the first time raising a novel technical issue with our rules that has never been raised over the past 6 months, certainly would qualify under that provision. I would also remind my colleagues that they did not object when they were in charge. For example, in 2016, Chairman Chaffetz summoned FBI Director Comey before our committee with less than 48 hours notice. The only unusual circumstance in that case was that he did not like the fact that no criminal charges were brought against Hillary Clinton. The bigger point here is that members were aware that we were going to vote on contempt this week. It was the subject of many letters back and forth between the committee and the administration, and the ranking member was copied on all of our letters. I've explained my position, and I have offered to work in good faith with the ranking member going forward. Now let's proceed.
Mr. Chairman, could I just comment?
I recognize the gentleman.
I thank the gentleman. I appreciate what you just said. The bottom line is exactly what the gentleman from North Carolina said earlier. The notice is legally defective. It will, in fact, be litigated. The remedy was real simple. The remedy was real simple. Just wait before you do this contempt vote. But understand, you guys can't do that because you are so concerned the Supreme Court's going to rule on this that you got to get it done before that happens. We know that. Members of this committee have said they're trying to influence the court. So it was real simple. We, as the gentleman from North Carolina pointed out, we specifically wanted this notice for 3 full days, 72 hours, because when you're getting ready for something as important as holding a Secretary of Commerce and the Attorney General of the United States in contempt, for goodness sake, you want every minute you can to be ready for that debate. That's what's at stake here. So the notice is in fact defective. It will in fact be litigated. The remedy is real simple: postpone the hearing, but you weren't willing to do that because there's a Supreme Court case coming any day now. And that's the problem. And that's why the gentleman's point of order is exactly right. We should postpone this hearing on this particular. We can have the markup on the other issues, not on this one. That I yield back.
Thank you very much. Without objection, the amendment is considered read and will serve as the base text for purposes of amendment. I now recognize.
No. Has the chair ruled on?
I've ruled it. I've already ruled.
I appeal the ruling of the chair.
All those in favor of the appeal signify by saying aye. Aye. All those opposed, no. No.
Ask for a roll call vote, Mr. Chairman.
Roll call. Clerk will call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? No. Ms. Maloney votes no. Ms. Norton? Mr. Clay? Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper?
No.
Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? No. Mr. Krishnamurthy votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Ruda? No. Mr. Ruda votes no. Ms. Hill? No. Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Sarbanes votes no. Mr. Welch? Ms. Spear? Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence?
No.
Ms. Lawrence votes no. Ms. Plaskett? Mr. Khanna? No. Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Acacia-Cortez? Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Ms. Fox? Mr. Massey? Yes. Mr. Massey votes yes. Mr. Meadows?
Yes.
Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Mr. Comer? Yes. Mr. Comer votes yes. Mr. Cloud? Mr. Gibbs? Yes. Mr. Gibbs votes yes. Mr. Higgins? Yes. Mr. Higgins votes yes. Mr. Norman? Yes. Mr. Norman votes yes. Mr. Roy? Yes. Mr. Roy votes yes. Ms. Miller? Yes. Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Yes. Mr. Armstrong votes yes. Mr. Stubbe? Yes. Mr. Stubbe votes yes.
How is Mr. Grothman recorded?
Mr. Grothman is not recorded.
How is Ms. Fox recorded?
Ms. Fox is not recorded.
Is Mr. No, you go ahead. I'm sorry.
Ms. Fox votes yes.
How's Mr. DeSaulnier, please?
Mr. DeSaulnier is not recorded. Mr. DeSaulnier votes no.
How is Ms. Hill recorded?
Ms. Hill is recorded as no.
How's Ms. Norton recorded?
Ms. Norton is not recorded.
We get everybody.
Ms. Norton votes no.
We get everybody.
I just want to confirm that I was recorded.
Mr. Grothman,
Yes, was
you're
I?
recorded as yes.
Yeah.
How's Ms. Ocasio-Cortez?
Ms. Acacia-Cortez is not recorded. Ms. Acacia-Cortez votes no.
If no one else is voting, the clerk will give us the tally, please.
On this vote, we have 15 yeas and 20 noes.
Thank you very much. The motion is not agreed to. Let me just say this. I will work to clarify that rule. I now recognize myself for an opening statement. Today, we are considering a resolution and report that would recommend holding Attorney General William Barr and Secretary of Commerce Wilbur Ross in contempt of the Congress of the United States of America. They both refused to comply with duly authorized subpoenas issued by this committee that require them to produce documents relating to the addition of the citizenship question to the 2020 census against the advice of experts at the Census Bureau. What we have learned so far in this investigation is quite disturbing. Secretary Ross testified that he added the citizenship question, and I quote, solely, end of quote, in response to a request from the Department of Justice in December 2017 to help enforce the Voting Rights Act. We now know that this was a pretext. We've obtained evidence showing that Secretary Ross was aggressively pressing his staff to add the citizenship questions months before any request from the Justice Department in the spring of 2017. And he was doing it at the urging of the White House. Doing it at the urging of the White House. We also now have evidence that President Trump's advisors began discussing citizenship questions long before the president took office. After his inauguration, the president discussed the idea with his top White House aides, Reince Priebus and Steve Bannon, who in turn pressed it with Secretary Ross. And although we have limited information about this scheme, we've been blocked from fully determining the real reason the administration sought to add the citizenship question. That is because the Department of Justice and the Department of Commerce have refused to turn over key documents requested by this committee. For these reasons, on April 2nd, 2019, more than 2 months ago, this committee voted on a bipartisan basis to authorize subpoenas to Attorney General Barr and Secretary Ross for key documents regarding their efforts to add the citizenship question. During that time, we've tried repeatedly to resolve this impasse. As an accommodation, we narrowed the scope of the subpoenas to a very small subset of the documents we originally requested. I even invited Secretary Ross to meet with me personally so that we could discuss a way forward. Unfortunately, he refused. So that is why we are here today. I've heard some of the arguments against moving forward with the contempt vote today, and I would like to address them directly. First, there's a claim that the administration has produced more than 17,000 pages of documents. This is true, but the vast majority of these documents were already public. Others were heavily redacted, and many were not responsive to the subpoenas at all. That 17,000 number is meaningless if it includes printouts from the internet and pages that are blacked out. Second is a claim that we are trying to interfere with the Supreme Court case. This is simply not true. Congress has an independent responsibility under the Constitution to oversee the census, separate from any private litigation, period. The Supreme Court has made clear that Congress's authority does not cease just because private litigants bring a case. That argument also ignores the fact that we've been pursuing this investigation for more than a year, long before the Supreme Court ever took up the case. I first called for this investigation in March 2018 as a ranking member, just one day after Secretary Ross announced his decision. When I became chairman in January, I renewed these requests again well before the Supreme Court took the case. Finally, let me address the argument about executive privilege. Last night, we received a letter from the Department of Justice asking us to delay the vote today. So the President could even have more time than he has had to consider whether to claim executive privilege. That was it. They did not produce any of the key documents required by the subpoena coming from this committee. They did not commit to producing any of these key documents in the future. And they did not make any kind of counteroffer for these key documents. Here's the bottom line. We've been seeking these documents for more than a year. We issued a bipartisan subpoenas in April. We made clear that we were moving forward with contempt this week. And we offered that if they began producing one or two categories of the key documents in our subpoenas, we would be willing to consider postponing today's vote. But both departments declined this offer, which is why we are proceeding today. The census is critical to our democracy and critical to every single one of our constituents. The Constitution gives Congress the responsibility and the authority that the census is make sure that the census is working as it was intended to work. That includes making sure that it is used properly to allocate federal funds, apportion legislative districts, and for other purposes. We must protect the integrity of the census, and we must stand up for Congress's authority under the Constitution to conduct meaningful oversight. In addition, I want to update the committee on letters we just received a few moments ago from the Department of Justice and the Department of Commerce. The letters state that the President has asserted executive privilege over all of the subpoenaed documents. The letters assert executive privilege over the specific key documents that are essential to our inquiry and include a, quote, protective, end of quote, assertion of executive privilege over the rest of the documents. The agencies apparently waited until the last minute, the day before our contempt vote, to ask the President whether he wanted to assert the privilege. These subpoenas have been outstanding for more than 2 months. They are bipartisan. They are based on request letters sent months before that. They delineate specific, unredacted documents that are priorities for this committee. I wrote letters last week making it clear that the committee would vote on contempt this week if we did not receive a narrow subset of these documents. Yet, The agencies have produced none of the key unredacted documents required by the subpoena. They've made no commitments to produce any of these key documents, and they have made no counteroffers relating to these key documents. The Department of Justice's letter says that they were prepared to produce additional documents responsive to the subpoena. But they make clear, very clear, that they will not produce the key documents that we have identified as priorities. This does not appear to be an effort to engage in good faith negotiations or accommodations. Instead, it appears to be another example of the administration's blanket defiance of Congress's constitutionally mandated responsibilities. The report we are considering today anticipates many of the administration's arguments because they have been making them for months. For example, deliberative process and attorney-client privilege. For months, the Trump administration has claimed that the decision to add the citizenship question was made at the department level rather than at the White House. But now the president is asserting executive privilege over all of these documents. This begs the question, what is being hidden? Here's what I'm going to do. I'm having the copies of this letter made for every member so all of you can review it for yourselves. Next, we will proceed to debating the contempt motion. However, I will postpone the vote until later this afternoon so members have additional time to review this letter and any other materials they may deem necessary. And with that, before I yield to the ranking member, I want to reiterate that the amendment in the nature of a substitute will serve as the base text for the purpose of amendment. And now I recognize the distinguished ranking member of our committee, Mr. Jordan.
Why don't they want to know? That's the fundamental question. Why don't the Democrats want to know how many citizens are in the country? Go ask any person anywhere across this country, walking down the street, walk up to them and say, hey, do you think on the census we should ask how many citizens are in the country, or ask, are you a citizen? Every single person you will encounter will say, well, yeah, of course we should ask that. Their next question will be, aren't we doing that already? And of course we would all have to answer, yes, we are. We've been doing it for decades, doing it on the 10-year census, doing it on the American Survey annual census. Why don't they want to know? It's a question the United Nations recommends as a best practice. It's a question asked in numerous other countries. How did we get here today? How did we get to the point today where we're going to hold the Secretary of Commerce, the Attorney General of the United States, in contempt because we don't want to ask a question that everyone in the country thinks we're already asking, and in fact we are? That's the bottom line. You can do all this, the letters back and forth, negotiations back and forth, and I'm all for getting information. You can do all that. But when you boil it all down, it's a fundamental question. Why don't they want to know? Why don't they want to know? Democrats know it. Here's the other thing they know. Democrats know the Supreme Court will rule by the end of this month on the citizenship question. But they hope to use this committee's oversight power to create a controversy around this issue, try to impact the court's decision. To that end, the Democrats now want to hold, as I said, both the Secretary of Commerce and the Attorney General in contempt because of an alleged lack of cooperation with the Democrats' request for information. Facts stand in stark contrast to the Democrats' claims that they are not getting information from the agencies. Trump administration has cooperated, continues to cooperate with chairman in this, I believe, partisan investigation. The administration has produced not 17,000, 31,000 pages of documents, 14,000 from Commerce, 17,000 from Justice, relating to this question, the citizenship question. Secretary Ross sat here for 6 hours, answered all kinds of questions. Several administration witnesses have voluntarily participated in day-long transcribed interviews, providing information at the heart of the chairman's partisan investigation. In fact, just yesterday, transcribed interview with a former commerce official. This interview lasted nearly the entire day. The committee has 2 more transcribed interviews scheduled in the next week. The idea that the administration is stonewalling this investigation, even in the chairman's words, engaged in a cover-up from the, quote, top, is just ridiculous and doesn't jive with the facts. Contempt of Congress is a powerful tool, and it should be used responsibly. This is just another last-ditch attempt by the Democrats to muddy the waters around the citizenship question in a desperate hope that it will influence the Supreme Court's consideration of this issue. Instead of considering legislation about the question itself, something we can do, something we've been doing year after year, decade after decade, the Democrats are choosing to use their oversight authority to interfere with the Supreme Court. It's not what we should be doing. I urge members to vote against this, and again, remind everyone here, why don't they want to know? Why don't they want to know something that everyone in our district knows should be asked, knows has been asked, is just good common sense? I would say you can talk, it doesn't matter, Republicans, Democrats, Independent, you go talk. The only people who don't want to ask the question, Democrats around the country do, Republicans around the country do, Independents around the country do. The only ones who don't want to ask the question, Democrats in Washington. That's the only ones. Everyone else knows it needs to be asked. I will yield back, Mr. Chairman.
Thank you very much. The chair recognizes Mr. Connolly. Strike last word.
I thank the chair. Well, I guess the distinguished ranking member must live in a different world than I live in. And if he's looking for people who will go, why would we ask the citizenship question unless it's to deter people from complying? Welcome to Northern Virginia. We'd be happy to give you lots of people, independents, even Republicans and Democrats, who actually understand what's at foot here. That the citizenship question is not just a normal question. By the way, it hasn't been asked in the census since 1950, the year I was born, for a reason. Because it's going to intimidate and discourage. And it has to be seen in a context, the context of an anti-immigrant policy coming out of this White House. And it's designed to intimidate and instill fear. And the question isn't the one my distinguished friend has posed to us. The question is, what are they afraid of that we'll discover with this subpoena? If you have nothing to hide, you're proud of your policy and the formulation of this question, these documents would be flowing up here yesterday. Instead, as the distinguished chairman indicated, the administration's gone to extreme lengths in something that doesn't pass the laugh test to say executive privilege will cover all of the subpoena documents, all of them. And in that overreach by the administration, I believe will be their demise, because I don't believe any serious court in the land will uphold that new exertion of executive power vis-a-vis the legislature. It also comes in the context of massive voter suppression in this country when Republicans take over state houses and governor's offices. Millions of people have been purged from voter rolls unnecessarily and unfairly. Stringent voter ID laws designed to discourage certain voters, especially candidly voters of color, from participating in the free democratic electoral process. Cutting back on early voting. This has been a pattern to make it harder for people, certain people, to vote. So I would say to my friend from Ohio, come to my district and explain to them why we need this question and listen to their reactions. Because if you're looking for people who share our view about this question, I've got plenty of people in my district who share our point of view and get what's really at stake here and what the real agenda is. And that's why these subpoenas are so important. This isn't just a fight between the executive and legislative branch. This is about the future of our democratic process. Will free people be able freely to vote without worrying about intimidation, without worrying about questions that get at data they may not want to share or they're uncomfortable about? For good reason, in the climate of fear that's been created by this White House, and all too sadly by leadership from the other party in so many states. I find it interesting that the ranking member says to us very piously that the question of contempt is a serious matter and needs to be judiciously arrived at. I don't remember his saying that when my friends on the other side controlled this committee and railroaded the then Attorney General Eric Holder with a contempt citation that was designed for one purpose only, to discredit him and the administration. Even though, unlike this case, they were responding to document requests. There was no such consideration about the gravity of the matter then. And in this case, it's totally different. As the distinguished chairman pointed out, we got 17,000 pieces of paper, none of them responsive. Most of them redacted or redundant. It's a cynical ploy to say, check, we have responded. It's not true. For the sake of the people we represent, for the sake of new Americans who want to know that their legislators care about them and protect them, as any fellow American would have a right to expect, for the sake of the legislation and the sake of the legislative process and the role of our constitutional framework, we must support these subpoenas. And I proudly will today. I thank the chair.
Thank you very much. Chair recognizes Mr. Heiss. Strike the last word.
Move to strike the last word.
You recognize.
Look, everyone in this room is in favor of vigorous oversight, and I certainly as much as anyone else, but there's a right way and a wrong way to go about it, and holding administration officials who are already prepared to cooperate is not, it's just the wrong way to hold them in contempt when they're already expressing a willingness to cooperate. It's just not the way to go about business. The Attorney General and the Commerce Secretary have both stated that they are willing to provide this committee with everything they want after the Supreme Court makes its ruling. And we know that that decision is coming any day now. So the question then becomes, why is it so important to the Democrats right now to push for this contempt vote? And the only answer is because they want to influence the Supreme Court. And that is not the role of this committee. It's not the role of this committee to be trying to influence or sway the Supreme Court. And we know that is a desire of this committee because it's been stated by a member of this committee with NPR, who literally stated that the Democrats sought information from the Commerce Department so that the courts can use it. That's public knowledge. It's what has been stated by even a member of this very committee here. So even if you set that aside, if you set aside the attempt of the majority to influence the Supreme Court, there's also issues taking place here with the mere process of it all. Contempt is something that should be reserved after all other options have been placed on the table, and we are not there. We are far from that. This is an investigation that's still underway. We've not run up against a brick wall. There's no reason for a vote of contempt at this point. As has already been stated, there are transcribed interviews that are still scheduled just in the next couple of weeks. We've not completed what investigations are even underway, and I understand the majority party is frustrated that they've not received what they want, some vast nefarious conspiracy in this census question. I get that. But the issue is that we're still underway with investigations here, and this is not the time to have a contempt resolution. Look, and the American people just need to know what's going on here. Democrats simply do not want to have a citizenship question. And it is important for us to ask why. We know that that question cannot be used for immigration enforcement. It cannot be used for deportation. These types of things are in federal law. So the question is, why do the Democrats not want to know how many citizens are in this country? Is that asking too much for us to know how many citizens are in this country, even how many non-citizens are in this country? That's information we ought to know. And the question becomes, why is it that the Democrats are fighting tooth and nail to prevent that question from being asked? That is the issue here. And I thank the chairman. I yield back.
Ms. Ocasio-Cortez, strike the word.
Thank you. You know, so many of our folks across the aisle think that this is a debate about whether we should be asking who is a citizen or not in this country. The census is a constitutionally mandated operation that we are required to implement every 10 years. It is one of the most vital and sensitive things that we do in our government. Any change to the census, any addition of a question, usually takes 5 years of a process to make sure that it is vetted, that every word has been tested, to make sure that it is effective, because it is one of the most important things that we do. So it's not that I want to, this is not about whether or not I want to know who is a citizen in the United States or not. What I want to know is why this question was added, why 2 years have been shaved off of that 5-year process. I want to know why we have skipped every normal mandated procedure in testing how this question gets added in the census. I want to know why this question was magically added after we have seen that a political operative knew and detailed an intent to intimidate racial and immigrant communities for a partisan purpose, saying this will hurt Democrats and help Republicans. That's what I want to know. I want to know why Secretary Ross continued to meet with people of disturbing political affiliations after his own administration warned him to stop. He came right here and I asked him, did you continue speaking with him after this? He told me no, we had an email, and he did. He did. I want to know why people like Chris Kobach, with a documented history of overseeing effects. He has a resume of voter suppression techniques in the state of Kansas. I want to know why folks like that have their fingerprints all over the most sensitive census operations that we have as a United States government. This determines who is here. This determines who has power in the United States of America. That is what we want to know. I want to know about corruption. That's what I want to know about, the racism and the very disturbing history that we're seeing here. That's what I want to know. And so we gave the opportunity to ask. We asked, why are all of these things happening? Why is all of this connected? Why are there so many people, everyone from Steve Bannon to Chris Kobach, having their fingerprints and their political intent all over the United States Census? Why? And what did we get? Nothing. No response. Stonewalling, we're getting obstruction, we're getting a lack of answers. I don't want to issue a subpoena. Nobody wants to be in a position where you have to issue a subpoena of an administration official, because we are a co-equal branch of government, and it should be expected that when we ask a question, we get a response. But when we don't, we have to do our job. No one wants to be in a position where we have to issue a subpoena. But today, because of the Secretary and because of the Attorney General's refusal to cooperate with a co-equal branch of government, we have no choice. This is about the rule of law. This is about the respect of our institutions, and this is about the power of all of us as a body, as the United States Congress, and the integrity of the government of the United States. Thank you very much. I yield the rest of my time to the chair.
The gentlelady yield. Let me say this
Yes.
to the gentlelady. Thank you very much for your comments. When I became chairman of this committee, I made it very clear that I took the issuance of subpoenas very, very, very seriously. I don't know if you know it, but in the past, we have had chairmen that have literally put out hundreds of subpoenas. We've put out very, very few. And we've been very, very careful for the very reasons that you just stated. We see it as a very, very serious matter. And you're absolutely right. We have come to this point. And we need to be very clear. You're right. This is our job. And I would consider it legislative malpractice if we don't do our job. We are not sworn to the president. We're not sworn to our party. We're sworn to the Constitution. And so I want to thank you for your comments. Mr. Meadows.
Thank you, Mr. Chairman. In moving to strike the last word, I want to make some comments. And part of that, in spite of the divisive arguments that we have from both sides of the aisle, I do want to acknowledge the chairman's willingness to work with me in trying to actually get some of the transcribed interview witnesses to appear before this committee. And so I want to thank the chairman for that. I fundamentally disagree with the timetable of holding Secretary Ross in contempt of Congress based on two main factors. One is this question will be resolved by the highest court in the land within the next 2 weeks. And we know that it could very well happen next week. And any legislative purpose that this body has certainly could be conducted in a very methodical way. And as we work towards handling any legislative oversight, I fail to see how a delay of 1 or at most 2 weeks would hamper our legislative authority. Secondly, I think probably the bigger issue is as we work to compel witnesses, and the chairman knows full well that I've been willing to sign on bipartisan letters. I've been willing to work in a bipartisan way to make sure even this administration complies with providing the information that this committee holds. I would suggest, respectfully suggest, that when we rush to hold people in contempt, it has a chilling effect on anybody wanting to go the extra mile to actually provide documents. If the ultimate conclusion is that we're going to hold people in contempt, and in this case, now that executive privilege has actually been exercised, it becomes very, very troubling in terms of the cooperative ability that this committee has long espoused. Now, that being said, obviously, I would respectfully ask the chairman. I appreciate his willingness to hold a vote on contempt for later today, but I would respectfully ask him to hold off until after the Supreme Court ruling to actually have this particular vote. Now, there are some that would argue we're a totally separate branch, and actually I would join them in that argument. But I will say this, that when you have something that is actually being adjudicated by the Supreme Court, and we know that indeed that their decision will be made known to the American people and really be binding in law within the next 2 weeks, why the rush? Why the rush? And so, Mr. Chairman, I respectfully disagree with this contempt vote. Certainly am prepared to offer amendments if the chairman plans to go through with this vote, but would respectfully ask him to consider delaying a vote on contempt for at least 2 weeks. I yield back.
Mr. Lynch.
Thank you, Mr. Chairman. Let me start out by just addressing this claim that Wilbur Ross and others have been cooperative. Anyone who was here for the long duration of Secretary Ross's testimony must agree, regardless of what side of the aisle you're on, that was painful. That was painful. He was anything but cooperative before this committee. Every question was dragged out and designed. Every answer was designed to produce pain and to consume time. And he was the most uncooperative. He feigned, inability to answer questions on a consistent basis. Let me also just talk about our ability to influence the Supreme Court in their decision. Okay, so for the entire history of this country, the Supreme Court has jealously guarded their right to determine what the Constitution requires. And we can go back to Marbury versus Madison and Justice Marshall. They have jealously guarded that decision. And the claim that what's going on in this committee room here is going to influence their decision, I can hear them laughing. I can hear them laughing at that proposition. That is absolutely ridiculous. And if you know how the Supreme Court works, that decision, that opinion has been written. That decision has been made before we bang the gavel on this hearing. Let me also talk about the other levels of cooperation. We were told, you should just wait a bit, because they're cooperating. Can I get, so this is one of the 17,000 these are the key documents that we asked the Secretary to provide us with. This is not helpful.
Will the gentleman yield? Is that from this production or from the production we got during the Obama administration?
Come on now.
Come on, I can show you likewise.
Well, look, reclaiming my time. This is not helpful. So 17,000 of these does not help the process. Let me also talk about. So this is one of the key documents that we were really trying to get. This is Wilbur Ross. This is from Earl Comstock to Wilbur Ross. And can I put that one up on the screen as well? And this reads, I agree, Mr. Secretary. On the citizenship question, we will get that in place. The broad topics were what we sent to Congress earlier this year as required. It's next March in 2018 when the final 2020 decennial census questions are submitted to Congress. We need to work with the Justice to get them to request the citizenship be added back as a census question. So when Mr. Ross testified here, he said that he got the request from Justice, and then the process began. This email indicates that 7 months prior, he was working with Mr. Comstock to get the citizenship question put in place. So this is not cooperation. This is his conduct is misleading Congress, not cooperating. So that's why I believe that the time is now to vote on contempt. We have given them plenty of time in terms of truly cooperating with the process. And this is, as Ms. Ocasio-Cortez has said, this is a core constitutional duty on our part to perform, to make sure that the laws are upheld, that we support and defend the Constitution. This is essential in that task, in that duty. So the proposition that these folks have been cooperative is preposterous. It is indeed laughable. They have been obstructionists from the very beginning, and I think the chairman has shown extreme patience and thoughtfulness and consideration for the other side of the aisle, but I think we've reached our limit, and I think we should proceed on contempt. Mr. Chairman, I yield. Yeah, I yield.
The President has made it clear we're fighting all the subpoenas from the House Democrats. All the subpoenas. And I want to enter into the record this article dated April 24th, 2019, entitled Trump, we are fighting all the subpoenas from House Democrats without objection, so ordered. I want to thank the gentleman for yielding.
Mr. Chairman, I have an amendment at the desk.
Ooh, where are we?
Right here, Mr. Chairman. I have an
Oh,
amendment
okay,
at the
Ms.
desk.
Tice.
I have an amendment at the desk.
We will pause for a second. We want to review the amendment. Thank you. Clerk will distribute the amendment to all members. And then I want to have a chance to read it. Does every member have a copy of the amendment? The clerk will read it.
An amendment to the amendment in the nature of a substitute offered by Mr. Heiss of Georgia.
Very well. Ms. Heiss.
Thank you, Mr. Chairman. Just in light of the conversation that is currently underway, like it or not, agree with details or not, the fact is that the Attorney General and the Secretary of Commerce have cooperated with this committee and continue to cooperate, both by coming for as witnesses to this committee, providing documents, and publicly stating that they will continue to cooperate with this committee. And they themselves are saying after the Supreme Court decision, they'll supply additional documents. They just don't want themselves to be involved in interfering or trying to influence the Supreme Court. And I think it just needs to go on record that they have, and they continue to cooperate with this committee, and that's what this amendment states, and I would urge my colleagues on both sides of the aisle to support it. Thank you. I yield back.
Let me say this. I oppose this amendment. Let me tell you why. First of all, I don't agree with it. The cooperation, it's already been stated quite clearly that the cooperation has not been all that said in this amendment. As a matter of fact, we have been over backwards trying to get the documents that we wanted. And I want to take this moment to compliment Mr. Meadows, who worked very, very hard, and he was able to get us the three witnesses that we wanted, but we also needed the documents, and we needed specific documents. I want to thank him for all of those efforts, and so he was successful in that role, but not as successful, and it's not because he didn't try to accomplish it. We weren't able to get that done. And even up until the last minute, the administration has said basically they're not going to give us the documents. Now, a statement has been made several times that I want to clear up, and I checked with staff because I had not heard this. The administration, to my knowledge, has never said that they are going to give us the documents that we want after any kind of decision, but that's irrelevant anyway, because we are an independent body. This is about us doing our job, us dealing with the census. Ms. Maloney, who has worked so hard on this for all the 20-some years I've been on this committee, knows what I'm talking about. So For those reasons, I would object to the amendment. Anybody else want to be recognized?
Mr. Chairman.
Yes, sir. Yeah, Mr. Clay.
Thank you, Mr. Chairman. I move to strike the last word.
Very well.
I'm,
Can you strike that?
are we under consideration, or is this amendment under consideration? It's been offered. I seek recognition to oppose the amendment.
Gentleman's recognized.
Thank you, Mr. Chairman. And my friend, Mr. Heiss, talked to, in this amendment, says that there has been significant cooperation from this administration, which is, that's not factual. There has been no cooperation. And let me share with my Republican colleagues an example of what took place yesterday. You know, in fact, the Department of Commerce refused for more than 2 months to make officials available for transcribed interviews, so the department relented only after the committee made clear it would subpoena them. We held one of those interviews yesterday with James Uthmeyer from the Department of Commerce. Mr. Uthmeyer is a key witness. He worked directly with Secretary Ross to add the citizenship question. He communicated with the White House about it, and he wrote the secret memo from the Department of Commerce to the Department of Justice. But yesterday, following instructions from the Department of Commerce, Mr. Uthmeyer refused to answer at least 100 questions from committee staff. He refused to say what he discussed with Secretary Ross. He refused to say who he talked to at the White House, and he refused to tell us what was in the secret memo to DOJ. In other words, the interview was just one more example of obstruction from this administration. So to call this cooperation on the part of the administration is just not factual. And so we need to be honest in this committee about where we're going, what our authority is, and as my friend from Massachusetts said, we do have the authority to issue subpoenas, to get to the truth, to get to the facts. And this is, Mr. Chairman said, this is serious business. This is about how we document all Americans, how we count them every 10 years in accordance to the Constitution, and what is riding on all of that data, all of that information. We need to be, we need to uphold our duty, and we all took an oath to do that. And so why now we are blocking for an administration that has no sense of the law, have conducted themselves in a lawless manner, is beyond me. And so at this point, Mr. Chairman, I would just say the amendment seems to be a farce, and I urge this committee to vote it down. And at this point, I'd like to yield the balance of my time to the gentleman from Maryland.
Thank you. Thank the gentleman for yielding. I just wanted to commend the chairman for the deliberate and conscientious way in which you have proceeded on this matter, because the language of this amendment, which alludes to the fact that the courts will take some measure and note of how the proceedings were undertaken, sort of calls to mind how careful you've been. And I actually think that if this gets into a position where the courts are having to make a judgment about where the cooperation was being initiated, and who was being careful and who was dotting all the i's and crossing all the t's, the courts are going to conclude that that's exactly what you've done, Mr. Chairman. And I think that that will ultimately carry the day in terms of where these requests for information come down. So thank you for that. I yield back my time.
Let me say to the gentleman, the chair has been very careful, very. I don't like being in this position. I do not. But I'm going to defend this committee, and I'm going to defend the integrity of this committee. And we have issued duly, properly done subpoenas, and we have to make sure that we do every single thing in our power to enforce it. And I thank you. I thank the gentleman.
Mr. Chairman, move to strike last word.
What am I? Oh.
Me, Mark.
Oh, no, no.
Thank you, Mr. Chairman. I want to just weigh in on actually the transcribed interview and this amendment. Literally, what we've got is both sides characterizing what we believe to be the truth. And somewhere between the way it's being characterized on the other side and by the way it's being characterized here is probably the truth. But let's make sure that we're clear. The interview that happened yesterday was one that you and I worked on together to make sure that this individual got there. And I know my good friend from Missouri is talking about all the questions that weren't answered. But the questions that were answered, you come on back. You can come on back and sit down. I'm not going to say anything negative about you. So, but some of the questions that were answered was the fact that that witness had nothing to do, didn't actually have any position with Chris Cobalt, Mark Newman, and didn't even know who Hoffeller was. And I mean, and he did answer those questions. And so let's make sure that we're fully engaged in terms of what happened and what didn't happen. And I say that respectfully to my good friend. And yet I want to come back to one other key issue as we're dealing with this amendment. We keep talking about how this is not about the Supreme Court case and it's about legitimate oversight and we've got to do this. And I guess the question I have is, since we're hearing a markup and since a member of this very committee, Ms. Eleanor Holmes Norton, has put forth a bill that would strike the citizenship question from the census, why are we not having a markup on that bill? This is a markup, and instead we're talking about contempt instead of actually having a markup on the very bill that would be the legislative responsibility of this very committee. So if we're wanting to be serious about it, why don't we get serious and actually do a markup on a bill that would prohibit it and actually move it to the floor? And because my friend is so nice and smiling, I will yield to the gentleman for a quick question in case we need to go back and forth from Missouri.
And let me thank the gentleman from North Carolina for yielding. But, the issue here is, one, did the Secretary of Commerce, Ross, come here to this committee and
For 7 hours.
and not be factual?
Well, now,
I don't care how much time
I would
he spent
caution.
here.
I would caution the gentleman,
I
because
didn't
if he lied to this committee,
Yeah, I think it's serious.
I want
but
to let's bring him and Michael Cohen back in here and let's hold them both.
Wait a minute,
I'll reclaim my time.
Wait a minute, hold it. One at a time, it's your time. Okay. You got your time.
So,
Are you yielding?
I will yield 30 more seconds to the gentleman to make a incorrect point.
I mean, look, you can call it incorrect if you like. You know it's factual. That we were told one scenario of how the question got to the census.
Right.
And we know that that's not true after we have reviewed the evidence. And know that the start date was incorrect, that the genesis of it about the protecting the Voting Rights Act, are you serious?
So reclaiming my time, I will work with the gentleman and the chairman to make sure that any testimony that was false is certainly corrected. I think we have an obligation to do that. I would remind the gentleman that Mr. Cohen actually came here and actually did lie to this committee. And so we've got an obligation, and if the gentleman is willing to work with me on Mr. Ross, I will work, or work with me on Mr. Cohen, I will work with him on Mr. Ross.
The gentleman would yield. I think.
Are you willing to work with me on both of those?
I think Chairman Cummings has stated the
I was asking the gentleman from Missouri, are you willing to work with me on both of those issues?
I'm willing to work with you on the Ross issue.
Yeah, I bet. All right.
Right.
I will yield back to the chairman.
It's been engaging.
Very
Thank
well.
you.
Very well. Gentleman yields back. There being no further discussion.
Mr. Chairman,
Oh, okay. Okay, who's next? Do we go to
Mr. Chairman,
on the Heights Amendment? On the
I
Heights
have an
Amendment?
amendment at the desk.
No.
Heiss Amendment.
Heights. Are you speaking on the Heights Amendment?
No, I want to talk on the contempt.
Okay. Then you gotta hold on. The question now occurs on the amendment offered by Mr. Heiss. All those in favor signify by saying aye. All those opposed, no. No. In the opinion, the
Mr. Chair, ask for roll call.
roll call.
That's
That's right. What we're going to do to the clerk and to members of the committee, we're going to hold the votes till probably around 4 o'clock so that people will be present. I know everybody wants to be present for these votes in fairness to everybody, and you'll have plenty of notice, all right? All right.
Okay.
Gentleman has an amendment?
No, we'll go back to this side.
Okay.
And actually, Mr. Raskin is next.
Mr. Raskin.
Mr. Chairman, thank you very much. What are they afraid of? I think that the gentleman from Ohio asked the critical question. What are they afraid of? Well, 3 federal district courts have ruled that the citizenship question proceeded on a pretextual basis because they violated every rule in the book. Every rule and provision of the Administrative Procedures Act was violated along the way to putting that in. But we couldn't figure out, well, what exactly was behind the citizenship question that was implanted totally outside of regular governmental administrative process. Well, one of the documents came back heavily redacted, but there's enough truth in it, Mr. Chairman, that we can actually figure out what is really going on. It's one of the clues, and I'd ask the staff to put it up on the screen if they would. So this is an email sent by Wilbur Ross, the Secretary of Commerce, on May 2nd, 2017. Now you see most of that redacted part, but a very critical sentence appears sandwiched in between the redactions, Mr. Chairman. Quote, worst of all, they emphasize that they have settled with Congress on the questions to be asked. I am mystified why nothing have been done in response to my months-old request that we include the citizenship question. Why not? Now, notice the date of that email, Mr. Chairman. That's May 2nd, 2017. But Secretary Ross said that he added the citizenship question, as you quoted, solely in response to a request from the Department of Justice in December of 2017, 7 months later. And yet here he is in May of 2017, 7 months before, saying that he had been pressing for the citizenship question months before that. So we at least have a 7 months lie, maybe an 8 or 9 or 10 or 11 or 12 months lie.
Will the gentleman yield?
Yes.
Does the gentleman suggest that discourse between the executive branch Americans that serve the citizenry be suppressed? Does the gentleman suggest that common discourse that takes place between staff amongst the executive branch, the legislative branch, and the judicial branches of our government, does he suggest that that communication be suppressed?
Reclaiming my time, thank you for asking that excellent question. First of all, I'm not saying there's anything illegal about him having written this, but I think that it is highly dubious, if not lawless, for him to have testified that the sole reason for inserting the citizenship question was a request from the Department of Justice about the Voting Rights Act, which was his testimony before this committee. That's number one. Number two is an article appears in the New York Times, Mr. Chairman, on May 29th, 2019, headline, "Deceased GOP Strategist Hard Drives Reveal New Details on the Census Citizenship Question." Quote, "Thomas Hofeller achieved near mythic status in the Republican Party as the Michelangelo of gerrymandering, the architect of partisan political maps that cemented the party's dominance across the country. But after he died last summer, his estranged daughter discovered hard drives in her father's home that revealed something else. Mr. Hofeller played a crucial role in the Trump administration's decision to add a citizenship question to the 2020 census. Files on those drives showed that he wrote a study in 2015 concluding that adding a citizenship question to the census would allow Republicans to draft even more extreme gerrymandered maps to stymie Democrats." Okay, now this is what they're afraid of America knowing. It's got nothing to do with the Supreme Court. Mr. Chairman, I'm baffled by the repeated claim that the purpose of the work of this committee is to influence the Supreme Court. Our colleagues know that every member of the committee on the majority side understands exactly how the Supreme Court works. If you want to go to the Supreme Court, you bring a case or controversy under Article 3 before the Supreme Court. And if you want to intervene in somebody else's case, you apply for it. If you want to do an amicus brief, you do that. Are they accusing us of unethical or unlawful conduct in trying to get material to the Supreme Court? It's ridiculous. The Supreme Court justices know exactly how they're supposed to proceed. We have an independent constitutional obligation under Article 1, Section 2 to conduct the census. That's in the purview of the legislative branch, Mr. Chairman. That's our job, to see that the American people are counted. The very first sentence of the Constitution is, "We the people, in order to form a more perfect union," and so on. Then it flows directly into Article 1 of the Constitution, setting forth the powers and the duties of Congress, and one of them is to conduct a decennial census, an actual enumeration of the people, everybody. They might not like the fact that women were counted when women couldn't vote, or children are counted today even though they can't vote. They might not like the fact that non-citizens are counted. Everybody is counted under our census. That's what we fear the administration is trying to disrupt, and the truth has come out about it. Now, Mr. Chairman, you have acted with utter and characteristic reason and with a lot of caution in how you've proceeded. This contempt citation is long overdue, it is urgent, and is overwhelmingly justified. I yield back.
Mr. Chairman, I have a unanimous consent request.
Without objection.
Mr. Chairman, I would ask unanimous consent that we put in an article from June the 2nd of 2019 from the Wall Street Journal editorial board, which it says census target, and that's John Roberts, which actually contradicts everything that the gentleman from Maryland just put. I ask unanimous consent and be included in the record.
Without objection. So ordered. Ms. Higgins.
Mr. Chairman, I have an amendment at the desk.
Gentleman has an amendment at the desk. Has the amendment been distributed to all members? It has not. Well, let's just hold up for a second and get it distributed. Members, let me say this. If you got amendments, would you let us have them, please? Because I don't mind being here all day, but the fact is that we've got to, we got to at least be able to read them. Does every member now have the amendment? All right. Higgins. Clerk will report.
An amendment to the amendment in the nature of a substitute offered by Mr. Higgins of Louisiana.
Without objection, the reading of the amendment is dispensed with. Mr. Higgins. Ms. Higgins?
Thank you, Mr.
You're recognized.
Chairman. I'm recognized. Mr. Chairman, my amendment states that resolved that President Trump has exerted executive privilege over documents sought pursuant to the subpoena issued by the committee on April 2nd, 2019. This hearing is reflective of the vitriol and division that we witness unnecessarily within our nation, partially because as the American citizenry observes the actions of this Congress, they see it not reflected in their own communities, in their own families and hearts, in their own intent for the future of our country. We have clearly established constitutional parameters for the executive branch, the legislative branch, and the judicial branch of our government. In the pending court case, Supreme Court case before the United States, the dissent regarding a case that they have determined to hear, warned, it was warning, written warnings that specific individuals, including the secretary, that's now being considered for contempt, be not subject to public inquiry. Now, this was a writ by two Supreme Court justices, and the problem here, it is witnessed by the American people, is that this is certainly, could we get more public? And this is why the actions of this committee can influence a pending Supreme Court case. For the president, pardon me, one moment, sir, and then yes, for the president to have to exercise executive privilege is reflective of the kind of division and vitriol being presented to this nation unnecessarily so. We should let the Supreme Court move forward, make their decision, and then do our job very publicly with the media present, and I yield to my distinguished friend.
I thank my friend from Louisiana. I just have two questions about the statement you just made. I just want to make sure I get it right. Is the implication that the American people have no First Amendment right to discuss, or members of Congress have no First Amendment or speech and debate clause right to discuss any matter that is in the Supreme Court, any case that's in the Supreme Court? That's my first question. And the second is, I'm sure that you, as I am, believe in taking the language of the Constitution seriously. Where does the language executive privilege appear in the Constitution?
In response to your first question, and I'll reclaim my time, it's never my intent to restrain the constitutional obligations of this body or this committee. However, a warning issued in writ by a sitting Supreme Court justice should be something carefully considered. And the two Supreme Court justices did indeed issue writ warning against public interview while this Supreme Court case, this very important Supreme Court case, was pending. And this is why the actions of this committee could potentially influence that case, and we would never want that done.
Would you share that warning with the committee, just because I've not seen that?
I shall. It's been shared before, but I shall. Regarding our obligation to recognize the
executive privilege, where in the Constitution?
Executive privilege, that's reflective of the parameters of our own constitutional authority.
Will the gentleman yield?
Yes, I yield.
Now, the gentleman's trying to get cute because he's a constitutional professor, and I get that. But he knows very well in the jurisprudence of this particular, and I'll be glad to go offline and we can have this debate, and I'll be glad to do that. But the gentleman knows all too well that executive privilege has been recognized. Does he not?
Well, there's a huge debate
just
about.
yes or no.
There's-
Do you
no,
know that it's been
but
recognized?
recognized by whom? There's a huge debate about it and what
I
the
reclaim
parameters
my
are.
time.
It's not written in the Constitution.
I reclaim my time, Mr. Chairman. I'd just like to say that this is the legislative branch of government, not the harass and attack branch of government. And this committee should not succumb to the level of vitriol and division that we witness unnecessarily across our nation, and I yield.
Can the gentleman yield? So is the gentleman from Maryland, is he strictly is going with the text of the Constitution? I mean, this would be a new move by the gentleman from Maryland.
All right.
Mr. Chairman.
Mr. Raskin.
Well, but I reluctantly rise in
Strike the
opposition
strike
to.
the last word, right?
I moved to strike the last word just in order to oppose the amendment. I'm not quite sure what the import of the amendment is. The president has at various times asserted executive privilege over everything. When he said that he didn't want anybody in the executive branch testifying, I think he said something to the effect of, I'll ask my staff to get me the exact words, but he said, no more subpoenas, no more cooperation, no do-overs. So for 2 years, we heard from the Republican leadership of this committee and the Judiciary Committee, we won't do any investigation into the lawlessness and criminality alleged in the administration because we'll allow the Mueller report to do it. And the Mueller report comes out and they said, well, we're not going to pursue any of the allegations there because that's a do-over. In any event, we understand that the Supreme Court has said and the courts have repeatedly ruled that the legislative branch of government, Congress, has investigative powers which are essential and integral to the lawmaking function. And yet this administration has tried to pull a curtain down over the executive branch and say we're not cooperating with the census investigation and we're not cooperating with the request for the president's tax returns. He's the first president in the last 7 or 8 who's not produced his tax returns. We're not going to cooperate with investigation into corruption in the White House Personnel Office where 25 people were denied security clearance. And then the professional staff was overruled by the president and his political appointees. And this committee is trying to get to the bottom of that. And they simply are not respecting the constitutional role of Congress. And that's something that I would hope every member of this committee, regardless of which side, would consider a grave threat to American democracy. My friends on the other side of the aisle got millions of documents in the Benghazi investigation and in Fast and Furious and in the Hillary Clinton email investigation. I can go on and on. They did a great job.
Well, we're still missing 30,000 emails, I can tell you that.
And I know you think you've got the right to them, and we would agree that Congress has the right to obtain any information that it wants. This is not a frivolous partisan matter. This goes right to the heart of whether or not we're going to have constitutional government and the rule of law in the United States of America. When Congress asks for a document, it receives the document. When Congress asks someone to testify, in the normal course of business, the person comes to testify. We are not playing games here. This chairman has been utterly solicitous. He has bent over backwards for Secretary of Commerce to come before the committee. He wrote him a letter, and I hope somebody will pass me the letter, but he said, this is May 8th. He said, "Dear Mr. Secretary, I'd like to meet with you in person, preferably in the next 2 weeks, to ensure that you are fully apprised of the actions of your staff and to determine whether there is any way to resolve this impasse before initiating potential enforcement action." He closes by saying, in order to try to resolve this matter, I would like to meet with you directly before taking any further action. And I would like to determine whether there is any way we can address our committee's important oversight interests without further investigative steps or enforcement actions. I would encourage you to bring your counsel to this meeting so that we can discuss various options in an efficient and effective manner. My friends, I'm from Maryland. I know Congressman Cummings. Chairman Cummings is known as the gentleman of our state. He has done everything in his power to bring the Secretary of Commerce in and to give him every opportunity, and all we get from the administration is a middle finger. And that's not appropriate for the chairman of this committee. It's not appropriate for the power of Congress. So we're going to vindicate Article 1. If the president wants to assert he's got an executive privilege to not cooperate with Congress in any way, let him assert it. Why would we finger paint on our own contempt citation by posting this graffiti to it? This amendment undermines the meaning of the chairman's motion, and I oppose it.
Will the gentleman yield?
Yes, I will.
I want to follow up because as you talk about getting the middle finger, I want to make sure that the record is correct in that along with that, there have been 93,431 documents given to this very committee in compliance with the chairman's request. So 93 documents, and they haven't all been blacked out documents.
They're reclaiming my time. The gentleman who is a very sophisticated observer of the legislative process understands that you could produce millions of documents that are unresponsive, redacted, and completely irrelevant to the task at hand. What we are looking for is the evidence about why the citizenship question was actually added, and we get more from the newspapers and from honest citizens like the young woman whose father died who happened to find the hard disks that demonstrated what exactly happened. I oppose the motion. I yield back, Mr. Chairman.
Gentleman's time is
Mr.
expired.
Chairman.
Mr. Chairman, I move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman, and I'd like to yield to the gentleman from North Carolina.
So I want to follow up and make sure that the record's correct. I think it's inappropriate for us to hold up the individual who gave that document as this model citizen based on the pending allegations made against them. And I don't think the gentleman from Maryland would do that, but to act like that there's some kind of hero based on pending charges that are out there is certainly not appropriate. The other thing that I'd like to mention to the gentleman from Maryland is this. You know, for his indication that executive privilege is not in the Constitution, it's certainly implied power, and I don't think the gentleman would ever indicate that it would ever be overruled in terms of executive privilege. Here's the other thing. The Department of Justice is not in the Constitution, as my good friend Mr. Collins has pointed out multiple times, and yet it does exist.
We created it, yes. The lawmaking branch did.
So in doing that, to suggest that the strict letter of what is in the Constitution and what we abide by, the gentleman knows all too well that that's not always the case. In fact, he's taught lessons where it's not, and I yield to balance my time to the gentleman from Ohio.
I thank the gentleman for yielding. All we get is the middle finger from the administration is what the gentleman said. We just had a 22-month, $30 million investigation done by the special counsel. And my understanding, you can read it in the report, that the administration complied. That they allowed the White House counsel to testify for 30 hours. 19 lawyers, 40 FBI agents, 500 witnesses, 2,800 subpoenas, and they complied with it all. But the gentleman from Maryland says all we get from the administration, that's ridiculous. Oh, and you know what? It wasn't just 22 months. Because we said in a deposition with former Attorney General Jim Comey, the chairman was there, Mr. Meadows was there, a number of us were, I think Mr. Raskin was in that deposition, where James Comey said after 10 months of the FBI investigating, they had zero evidence of collusion. So 10 months of the FBI, 22 months of the special counsel, 32-month investigation that the administration complied with, and he says, the gentleman from Maryland says, all we get from them is the middle. That is just ridiculous. So maybe at some point, the administration says, you know what? We were falsely accused of conspiring with the Russians to impact the election, falsely accused. Maybe instead of, maybe the right, do we investigate the false accusations? It seems to me that the question would be, do we investigate the false accusations, or do we continue to look at something Bob Mueller spent 22 months on and came back and said no collusion? That Jim Comey testified and said after 10 months of the FBI look at it, no collusion.
Will the gentleman yield?
Of course I'll yield.
Well, can you show me where in the special counsel report Mr. Mueller said no collusion? Because I think if you read on pages 1 and 2, he says we don't address the matter of collusion, which is not a legal concept. He looked at the question whether there was sufficient evidence for criminal conspiracy.
Well,
collusion, there were more than 125 contacts between the Trump campaign and...
Hold up.
Minute 43.
Suspend the time. I've noticed something that's happening here that's disturbing. Tried to be flexible, but you all won't let me be flexible. When somebody has time, it's their time. I cannot have these people, members, talking past each other, and I mean, it just doesn't make sense. As a matter of fact, it opens the door to problems. So whoever's talking, I mean, let's go strictly by the rules. So the gentleman, you have time? Is it your time, sir?
My time.
All right,
Well,
is
it's Mr. Heiss's time, but he's yielded it to me when I thank the gentleman for doing that.
So who has the time now?
I got the time now.
You got the time.
Yeah.
You got,
And following the rules is important, and frankly,
all right, go ahead.
following the rules is important,
Start the
Mr.
clock.
Chairman. That's why the first issue raised in this committee hearing this morning was the fact that we didn't follow the rules on the notice requirement raised by the gentleman from North Carolina. You're exactly right. Following the rules is important.
Thank you, sir.
Thank you.
Are you finished?
No, I'm thinking.
Oh, okay.
There's so many things I want to respond to. I'm trying to prioritize. The bottom line is, of course it was, but for 2 years we've used the terms conspiracy, collusion, coordination interchangeably. But tell me, did the special counsel conclude that there was conspiracy or coordination between the Trump campaign and Russia to influence? No. And after 22 months of that and 10 months prior to that, the FBI was looking at the same darn thing. So 32 months of investigation, but the Democrats, they don't want to ask the key question. Why don't we investigate how the false accusation started in the first place? They don't want to do that. Thank goodness Attorney General of the United States is. They want to say, you know what, we're going to keep investigating something that the special counsel spent 22 months on, the FBI spent 10 months on. We're going to keep looking at that. Okay. Okay, that's where we're going to be. That's fine. But to say this administration hasn't complied and given the Congress a middle finger on when he allowed his White House counsel to testify for 30 hours is just not accurate. With that, I yield back to the gentleman from Georgia.
I yield back, Mr. Chairman.
All right, fine. There being no further discussion. What's that? Norman?
Mr. Chairman, I got
Last
an
one.
amendment on the desk.
No. Yeah, we're trying to get through this one first. Yeah, we got to rule on your brothers there. All right. The question now occurs on the amendment offered by Mr. Higgins. All in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the no.
Mr. Chairman, I ask for a recorded vote.
And we will have a recorded vote, and we will delay that until around 4 o'clock when we do all the other votes.
Mr. Chairman, I have a unanimous consent request.
Please.
Asked unanimous consent that be entered into the record in response to my distinguished friend's request. Document from the Supreme Court of the United States dated October 22nd, 2018, which in part states, as written by Justice Gorsuch and joined by Justice Thomas, that the next logical step regarding a stay of public interview, the next logical step is to simply stay all record discovery pending our review. They go on to say there's another factor here too, weighing in favor of a more complete stay, the need to protect the very review we invite. They specifically cite Secretary Ross here. I ask that this document be entered into the record.
Without objection, so ordered. Ms. Lawrence.
Thank you, Mr. Chairman, for holding this important business meeting. Each person on this dais took an oath of office to protect and defend the Constitution of the United States, and we repeat that oath of office each time we are fortunate enough to be elected to serve in this amazing body of Congress. However, this administration does not seem to understand the concept of separate but equal branches of government as outlined by the same Constitution that we as members of Congress and them as executive branch officials swore to protect and defend before taking this office. Frankly, my stomach are in knots constantly. I'm losing sleep because of this administration refusal to abide by the Constitution. We, Congress, have a constitutional obligation to conduct the oversight of the executive branch. Yet this administration complains each time we request information critical to fulfilling our investigative responsibilities. Today, we vote to hold Attorney General Barr and Secretary Ross in contempt of Congress for their complete disregard for the Constitution and refusal to provide this committee with relevant documents related to the committee's investigation and to the 2020 census. This is no small matter. An inaccurate census can cause damaging consequences, will have an impact not on Democratic districts, but all of our districts. Besides the obvious issue of incorrect representation of our congressional billions, I sit on appropriations, our tax dollars, who would I fight so hard to distribute to take care of the people of this country, billions of federal dollars that our community, Republican and Democrat, will be thrown into limbo due to incorrect data. Instead of doing our jobs and fulfilling our constitutional duty to comply with these investigations, this administration, and I will say it on the record, it seems my colleagues on the other aisle are more interested in protecting the president instead of the people of this country. Look no further than the president in his own words, who not long ago stated, "We are going to fight every subpoena." Excuse me, checks and balances. And the statement that he continued to make, the Democrats are trying to win 2020. No, Mr. President, Congress has the responsibility to conduct oversight on issues that are critical to this country, and I intend to fulfill that role. 2 months ago, this committee voted to subpoena Barr and Ross for documents related to the census. And we keep hearing this thing, just wait, just wait. Why are you rushing? Why are you rushing? 2 months. My colleagues on the other side are saying, wait. Well, I tell you, my constituents, the people who called me are asking, why aren't you doing your job, Congress? Get to work. Stop sitting around watching this happen. Didn't we put you in office to do your job? I urge my colleagues to support this resolution, not just for administration's sake, but we must maintain a separate but equal branch of government.
Would my friend yield?
And I yield.
Just for a question. If you had nothing to hide, if you were proud of the process that produced this question on the censorship, do you think you would defy even a simple civil request for the documents to support it? Presumably you're proud of that addition.
I have served in local government. I'm in federal government. I've been a mayor of a city. I've always been ready and available and transparent in any policy that I bring forward. And I welcome the debate because I knew it was my obligation for every oath of office, including this one, to share in a public, transparent process why we're doing what we do. Because at the end of the day, I don't work for Donald Trump. I don't work for an administration. I work for the people. This is a place where the people can get the answers. I yield back.
Mr. Norman.
Mr. Chairman, I have an amendment at the desk.
The clerk will distribute the amendment.
Mr. Chairman.
We're very pleased to have our distinguished former chairman in the room.
I notice your portrait is actually up on the wall, Mr. Chairman.
Let me make it clear that when I became chairman, I said, let's make sure the portraits go up. It's out of respect. And Mr. Ice and I went toe-to-toe quite a bit, but when all the dust settled, I have a lot of respect for him, and I really mean that. He taught me a lot, and I'm sure I taught him a few things too.
Will the chairman yield?
Yes, of course.
We wish he hadn't taught you quite so well.
But it's good to see you back, and you do. You look much younger than the portrait. No, that's not yet. As they said to me in the hospital, the Lord ain't finished with me yet. All right, let's, where are we?
Mr. Chairman, while you're thinking about that,
Mr. Connolly.
I was just going to say, welcome back, former Chairman Issa. And it took a Democrat to put your portrait back on the wall. And you know what, Mr. Chairman? Maybe we ought to follow Mr. Issa's procedures with respect to subpoenas. That might be a really cleansing act here on the committee. Yeah, exactly. I knew that wasn't so popular anymore on the other side of the
Touche.
Thank you.
All right, let's move forward. We needed a little break. And thank you for being here. The clerk will report the amendment.
An amendment to the amendment in the nature of a substitute offered by Mr. Norman of South Carolina.
Without objection, the reading of the amendment is dispensed with. Mr. Norman.
Thank you, Mr. Chairman. My amendment reads, and it's after the first resolve clause, to insert the following. Resolve that a citizenship question is not new and has appeared on every decennial census from 1820 to 1950 and on every long-form census from 1970 to 2000 and on every American Community Survey from 2005 to the present. And this was in response to my good friend, Congressman Connolly, mentioned that it has not been on the census. It really has been on this question has been asked. And if you go back on the 1980 long-form population survey, on this survey was in what state or foreign country was the person born? And if this person was born in a foreign country, is this person a naturalized citizen of the United States? Secondly, when did this person come to the United States to stay? Now, I wasn't around in 1950, but I think the common sense approach that many people have mentioned and realize is that now, with the influx of people from other countries, now more than ever, we need this question asked. And I would say that this is the meaningful way to do it, and it's something that is long overdue and should be done. I reserve.
I oppose the citizenship. I oppose this amendment. The citizenship question has not been included in the decennial census in decades. In addition, the administration bypassed the procedures for adding the question, so I oppose it.
Mr. Chairman, would you yield?
Oh, yeah.
Mr. Chairman, would you yield?
Oh, Ms. Connolly, I'm sorry.
I thank the chair. I'm just struck, I appreciate the points made by our friend, but Lord Almighty, 1950. Let's see, Harry Truman was in the White House. I Love Lucy had not yet hit television. Your mother, Miss Deborah Wasserman Schultz, was 4. We were still fighting in Korea, and, the world was just a wonderfully different place. And for the ensuing 69 years, which kind of is conveniently glossed over in this motion, we didn't do it.
Well, my friend,
Now, just one second, if you would allow me to finish my thought. And I appreciate the sincerity of the author of this amendment, but it's in a series of clearly dilatory motions by the other side. And I'm not quite sure why my friends on the other side are so anxious to protect the production of documents about a simple question, the answer to which could easily clarify our concerns or not. And it's the or not part that I guess I'm getting really suspicious about the more I get these amendments. What is it you're trying to protect? What is it you're afraid of? And oh, by the way, as Ms. Lawrence indicated, we all take an oath. I'm just curious, and I ask it rhetorically, at what point do you honor that oath, as opposed to protecting whoever's in the White House? And I'm really looking forward to the day that happens. All of my friends are sincere. They all took the same oath, and I'm deeply troubled by the fact that they don't see incumbent upon them some responsibility to hold the executive branch accountable at some level. And so, yeah, the citizenship question is indeed asked on the American Community Survey, which is a limited subgroup. But this resolution begs the question of impact. Our concerns on this side are twofold. One is, what is the motivation? What is the motivation for adding back this question after 69 years? And secondly, what is the impact? And we have expert testimony and evidence that the impact will be to reduce compliance with the census. And what could go wrong with that? Well, that affects the allocation of federal resources to localities, and it affects ultimately how people are represented in their state legislatures, their local boards and councils, and here in the United States Congress. And that's a legitimate concern for anyone who takes the oath we do as a member of Congress to guard against.
Will the gentleman yield for a
Well,
second?
yes, I will.
I support the gentleman's statement and point out that experts have said that adding the citizenship question will result in an undercount of 6.5 million Americans. 6 different heads of the Census Bureau, Republican and Democrat, came out against it, saying it will produce an undercount. And I'd like to place in the record the memo from Mr. Hoffler on the use of citizen voting age population in redistricting. And he says, and I
Without
quote,
objection, so ordered.
he says, and I quote, "A switch to the use of citizen voting age population as the redistricting population base for
Will the gentlelady
redistricting
yield?
would be advantageous, on your own time, would be advantageous to Republicans and non-Hispanic whites." He points out that this will benefit dramatically the Republican Party in redistricting, and says that it will also result in an extreme undercounting of minority populations in America. So I am opposed to the gentleman's amendment, and Mr. Chairman, I'd like to get back to the real purpose of this, which is the contempt, which I'd like to speak on.
Time has expired.
Mr. Chairman.
Ms. Jordan?
Yep.
Ms. Jordan is recognized.
I don't get why you're opposed. The amendment states 3 facts. For 130 years, the citizenship question was asked. It was on the long-form census for 30 years, and it's been on every American community survey from 2005 to present. 3 facts. 3 facts that say we asked this question. We've been doing it since 1820, for 200 years, in one form or another. That's all the amendment says. And the Democrats are opposed to putting facts, to putting truth in the resolution. I don't get that. Seems to me we've had all this wonderful talk about
Will the gentleman yield?
Getting the truth, getting answers. All this says, this amendment is as simple and as basic as you can make it. 3 factual statements. We have been asking this question for 200 years in one form or another, and for some reason, the Democrats, we've had 3 of them. The chairman and 2 others have said, oh, can't put it in the resolution. 3 statements that are absolutely true. 1 + 1 is 2. Can't put that in a resolution. Can't put facts and truth in the resolution. These are 3 factual statements. That's all his amendment does. We think that makes sense to put it in the resolution. I support the gentleman's amendment.
With the gentleman to yield.
Be happy to yield.
I think it's important that we look at these amendments in really trying to set a record. And I say that with all sincerity. I'm going to offer an amendment here shortly. But I think, Mr. Chairman, part of the consideration, because this, I believe, could be a landmark vote when you're holding an executive branch cabinet member in contempt at a particular time, it's part of history. And I think it's important that we get it right. I think it's important that we include all the facts, because historians later will come back and they will say, what was the context of when that happened? And so I think for us to just say we're going to exclude something or not have it included, I think is troublesome for the record. And I yield back to the gentleman.
Not one cabinet member, 2. This is historic. 2 of them. And all we're asking is, can you put in 3 factually, 3 true statements? And they're, nope, can't do that. We're in a hurry to hold 2 people in contempt about a question that's been asked for 200 stinking years. I don't get it.
Mr. Chairman, would you yield?
Be happy to yield to the gentleman from South Carolina.
Thank you. And let me just add, my friend on the other side cited 69 years. Well, it's not done but every 10 years. So the years are kind of misleading. Secondly, as my good friend from Louisiana mentioned, you know, technology has replaced door-to-door census gathering. And people used to go door-to-door and they would ask the question, are you a U.S. citizen? So that's it's kind of disingenuous to cite the years. And I would just add that the American Community Survey is not some random small survey. And like Mr. Jordan said, you know, this is a very simple amendment that really ought to be unanimous from everybody on this committee.
Ms. Wasserman Schultz.
Thank you. I want to move to strike the last word on this amendment.
Ladies recognized.
Particularly because the author and the minority is arguing that this was language that was asked on the census for decades, that it's something that, you know, we used to do and so should do again, and that there wasn't any issue with it before. However, that is not the case, and I would ask unanimous consent to enter this article from NBC News that quotes the Census Bureau at the time they discontinued asking the citizenship question in for the 1960 census.
Without objection, so ordered.
Thank you, Mr. Chairman. Where it says, any effort to ascertain citizenship, this is quoting the Census Bureau now, will inevitably jeopardize the overall accuracy of the population count, an argument the Bureau has consistently upheld over the years. So there are decisions made to both include and exclude questions. It has been repeatedly excluded and consistently excluded since the last time this question appeared on the census, directly because it results in an undercount. It results in fewer people being counted, which is directly contrary to the intent of having a census in the first place, and quite frankly, is the intent of the Republicans' desire to put the question back on the census, as evidenced and revealed by the documents that have been that have come to light, and which is why we need to make sure that we get more information to expose the true reasoning behind the administration's desire to add citizenship to the census once again, which we have significant evidence thus far that the reason is so that there's an undercount. So,
Will the gentlelady yield?
I'd be happy to yield to the gentleman from Maryland, the gentleman from Maryland behind me, and then, but I don't have much time.
Thank you very much. Your point is an excellent one, and all of the information that we needed about American citizens, we were able to get through the very mechanisms that the gentleman's amendment contains within it. So the reason why 3 district courts struck down putting the citizenship question on the form that's given to every American citizen is, 1, it's unnecessary. 2, it will in fact result in a severe undercount of millions of people. And 3, it was completely outside of the procedure and the rules. And it was the fact that the Secretary of Commerce apparently has tried to cover that up and suppress the fact of where it really came from that brings us here today. Mr. Chairman, we should proceed with the contempt motion.
Mr. Chairman, do I have any remaining time?
Yeah. No, you don't.
No, okay. Then I yield back.
All right, no further.
No soup for you.
Now, listen up. Very briefly, we got a vote. So I want to take the vote on this, if you don't mind. But go ahead, Ms.
Just want a recorded vote, ask for a recorded vote.
Well, not yet. Yeah, not yet. I know we're excited about it, the amendment, so let's slow it down a little bit. The question now occurs on the amendment offered by a distinguished gentleman, Mr. Norman. All those in favor signify by saying aye. Aye. Those opposed, no. 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 The noes have it, and we will roll call vote.
Yes, sir.
Very well. We will delay that until around 4 o'clock, when we do all the other votes.
And I have a unanimous consent request?
Yeah, please do.
Thank you, Mr. Chairman. Ask unanimous consent to insert into the record the American Community Survey dated 2019, where it asked the question on number 8.
Okay. Without objection to order. Very well. Now, let me tell members what we're doing. Is there others? We only have one vote, is that right?
We only have one vote. We could keep going.
Okay. Chairman, unanimous consent request.
Yeah.
I ask unanimous consent that the 3 courts that have actually ruled on this question and found it wanting be entered into the record, their opinions be entered into the record.
Without objection, so ordered.
I thank the chair.
Are we coming back to this?
We are coming back. There's a vote, ladies and gentlemen. There's only one vote, so we will come back to give people, hold on, give people a chance to get something to eat. We'll come back at 1 o'clock, right? What's the matter?
He's already.
No.
So when I come back, can I be recognized?
out of here for a minute. Come back about one.
said something. Yeah, I'm good on email. You all right? Yeah, I'm just waiting for you. So what? Hey, you ain't getting on till like 9 tonight. I don't know. Well, they're talking about doing these roll calls 4. So it's gonna be here still there. You know? And if they do that. More or less I want to say. No, I'm totally with that. You know, a lot of times I bring up, I was actually supposed to go grocery shopping today. Thought I'd be out by off by 3, but maybe if I get on the 5, I'm not too tired to go. Probably will. Yesterday I was. Yesterday I got off. I was like, you know what? It's not bothering me.
Committee will come to order. I have an amendment at the desk which has been distributed. I think, has it been distributed? Very well. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General of the United States, and Wilbur L. Ross, Jr., Secretary of Commerce, in contempt of Congress for refusal to comply with subpoenas duly issued by the Committee on Oversight and Reform.
The amendment shall be considered as read. I recognize myself for 5 minutes to describe my amendment. First, this amendment simply documents the letters we received this morning from the Departments of Justice and Commerce asserting executive privilege. Second, the amendment explains that the committee has concerns with the assertion in this case, such as the blanket quote, protective assertion of executive privilege, end of quote. Third, the amendment provides that even if this were a valid assertion, that assertion would be overcome because the committee has demonstrated our critical need for these documents, and we cannot obtain them expeditiously from another source. Finally, the amendment finds that the President's assertion does not change the fact that the Attorney General and the Secretary of Commerce are sadly in contempt. I encourage all members to support the amendment. Question now occurs on the amendment offered by Mr. Cummings. All those in favor signify by saying aye. Aye.
Aye.
All those signify by saying no. No. In the opinion, the ayes have it. The ayes have it.
We might as well, I'd respectfully ask for a roll call. If we're going to roll call all the others, we'll roll call this one as well, Mr. Chairman.
Very well. We will have roll call when we take the other votes. Thank you very much.
Mr. Chairman, I have an amendment at the desk.
Gentleman from North Carolina, Mr. Meadows, is recognized. Whoa.
Okay.
Has it been distributed? All right. Everybody has it? All right. Yes or no?
No, I think they're distributing it now, Mr. Chairman.
All right.
In the interest of time, Mr. Chairman, I'm willing to go ahead and speak on it if you want while they're, no, the parliamentarian doesn't want to do that.
Yeah, we just want to see. We know that it's a great amendment coming from you.
Thank you, Mr. Chairman.
Very thoughtful, I'm sure.
Actually, it is.
You act like you're surprised.
Well, sometimes mine aren't, but this one is. I think you'll agree.
All right, sir. Why are you taking it?
Does everyone have the amendment? And then the clerk reports.
Clerk will report.
An amendment to the amendment in the nature of a substitute offered by Mr. Meadows of North Carolina.
Very well. Mr. Meadows.
Thank you, Mr. Chairman. Obviously, this is a very short amendment, and I was sincere earlier when I was talking about this particular moment holding two cabinet members in contempt and what will be viewed by historians and perhaps by the courts, but certainly by historians at a later time, is the actions of Congress. And I think it's very important for us to lay out the context. And this is not a provocative amendment. Essentially, all it does is state the fact that the Supreme Court has already heard oral arguments on this particular issue of the citizenship question, and that they, as it relates to the legal challenges by this administration or those that are taken against this administration, and candidly that the Supreme Court is expected to rule on this. You want me to wait while? And candidly, that the Supreme Court is set to rule on this over the next couple of weeks, certainly by the end of June. And I just think from a historical perspective, adding this amendment would be an important addition to the resolution. And with that, I would encourage a bipartisan adoption of this amendment. I yield back.
Let me say this to the gentleman. I wish you had submitted this earlier. I mean, I have no problem with the amendment. But let me be clear. You rightfully so have said, and you've said it 3 or 4 times, and I totally agree with you, when you say that this is a significant moment in our history, the history of this country. I tell my constituents that 200 to 300, 400 years from now, people will look back at this moment and ask the question, what did you do? What did you do when you had an opportunity to defend the committee and the committee's integrity? What did you do when you had an opportunity to defend the democracy? What did you do when it came time for you to stand up and stand out and not betray generations yet unborn? And I want you to understand, and I'm saying this to all of us, that this is a significant moment. This moment is not just about us. It's not just about us. I'll be dancing with the angels when some of the ramifications of the things that are happening today are changed. But the fact is that we have got to, as Mr. Meadows has said it, and he said it quite eloquently, we got to get it right. We've got to get it right. And I lose sleep over this. When I thought about what Ms. Cortez said when she talked about how what happens with regard to the census touches everybody. And the thing that I think we all want is a fair count. A fair count. I think one thing that I love about the American spirit is about fairness. Fairness. And, you know, so, again, I see nothing wrong with the amendment. But I want to make sure we keep all of this in context. Not for us. I mean, because you know what? Sometimes when I think about the people who have sat in this room over the 23 years that I've been here, and some of them are dead. Some of them lost elections. Other ones just gave up. They just got frustrated. But they're not here. So I think about the idea that this is our watch. This is our watch. This is it right here. Nobody is trying to be harmful to our Attorney General. It's not about him. Nobody's trying to be harmful to the Secretary of Commerce. It's not about him. It's about our country. It's about this phenomenal country that allows people like yours truly to come up for parents with a fourth-grade education to rise up to the Congress of the United States of America. Come on now. And so I put it all in context too. And again, I accept I'm going to vote for the amendment. I wish you had gotten to me sooner because there's nothing wrong with it, all right? Who's next?
I thank the chairman.
Mr. Maloney, did you have something?
Mr. Chairman.
The question now.
Mr. Chairman.
Mr. Raskin.
Thank you very much. I move to strike the last word. I'm very skeptical of this amendment because it seems like there's been an effort from the very beginning to impute an illicit motive to what we are doing in trying to obtain information about the census and about the Department of Commerce's imposition of a citizenship question completely outside of the Administrative Procedures Act process, which is why 3 district courts struck it down. So I just don't know what the relevance of this sentence is, and I think I can see how it gives some support to the suggestion that has been circulated by the gentleman that we are somehow trying to impose ourselves on the Supreme Court, and we're not. We would be doing this if there were no case in the Supreme Court because we have an independent constitutional mandate and obligation to make sure that the United States Census counts every American person who's here in the country. That's our role. So I'm very skeptical of this sentence. I don't know, it seems to me, again, an example of just finger painting on the contempt motion. If you want to talk to people about the Supreme Court, talk to them. But I thought you guys were saying this has nothing to do with the Supreme Court, which is our position. Ooh. It's got nothing to do with the Supreme Court. My friend, Mr. Meadows, introduced before, and perhaps I misheard him, but he said he wanted to introduce into the record an article by Supreme Court Justice John Roberts, which refuted everything that I had said about the Constitution. The article, at least that was given to me, Census Target John Roberts, is not by John Roberts, it's about John Roberts.
That's correct.
It's written by the Wall Street Journal editorial board, and it is extremely unconvincing, to say the least, and I'd be happy to go through it with the gentleman. I also had the chance to read the passage that was cited by my friend from Louisiana in the ongoing census case, which was written by Justice Gorsuch and Thomas. Again, I've squinted very hard. I cannot see a single word in here which would suggest that the Congress of the United States should not be executing its constitutional obligations to make sure that there's a complete count in the census and for us to do oversight over the executive branch, nor is there anything here which
Will the gentleman yield for a short second?
By all means.
I want to applaud the points that you are raising because it's our constitutional right to exercise oversight, which is what and why we have had subpoenas, why we are voting on contempt, because we are not getting any cooperation from the other side. Now, this whole day I've sat here, and this side of the aisle, the Republican side of the aisle, you keep bringing up the Supreme Court. We don't. You do. You keep alleging that we're doing this for the Supreme Court. We're not doing this for the Supreme Court. We're doing it because we have asked for information about getting a proper and accurate count, and it has been stonewalled and stopped and roadblocked by the Republican side of the aisle and the executive branch. So I applaud the information that you've put forward, Representative Raskin, and I suggest we get back to oversight. And I would really respectfully like to ask my Republican colleagues to stop bringing up the Supreme Court.
Thank you very much, Ms. Maloney, and thank you for reclaiming my time. just to complete that point. So even in that dissenting excerpt from Justice Gorsuch, there's nothing in there which would suggest that we shouldn't be doing our job in the U.S. Congress to conduct oversight over the consensus, which we are constitutionally charged to supervise. So this is our responsibility. What are the three most important words in the Constitution of the United States? We got a lot of young people here today. We the people. How do we know who we the people are unless we go out and count all the people? That's the whole purpose of it. And we have mechanisms for doing it on a decennial basis, and the administration violated those mechanisms. 3 district courts said so. And we're trying to get to the bottom of it, and we've got all this information suggesting that it was a complete political hit job on the census because they thought that it would benefit the president's political party. Now, I can understand the urge to try to submerge all of this evidence, but Mr. Chairman, we have the obligation and the power and the right to get the information that we want. And I'm sorry, I cannot vote for this amendment as much as I would like to because it is finger painting on very serious business of the committee. And so I'm going to be voting no.
Yep,
Thank you
Mr.
very
Chairman, I move to strike the last word.
Chairman, I yield to strike the last word. Yield to Mr. Bettis.
I thank the gentleman. Let me just respond, and I want to be real clear, and I think the gentleman knows this. I have never, not today or prior to this, ever associated a motive or impugned a motive. And my unanimous consent acknowledged that it was a Wall Street Journal opinion and about John Roberts. And so I want to be clear about that.
I'm certain it was an honest mistake. Certainly.
Well, no, he wasn't. I mean, if we want to read back the record, I promise you that I can assure you that that's what I said. The second part of that is when we talk about impugning motives, I have purposely not quoted a member of this particular body on your side of the aisle who has said that that's the whole reason for that, has gone on record in the media to say that. And that individual knows that I have not used that individual's name, so to not impugn their motive. And so to suggest that there are motives here, I can tell you that there are people from your side of the aisle that are on the record that this is to influence the Supreme Court. Now, that being said, this amendment has nothing to do with that, and I think in the context of that, hopefully it is viewed in such a way to put a contextual framework around this vote so that historians 100 years from now can say that this is what was happening at the time that the vote took. Certainly your students would have liked to have had that in the record, and that's the total reason I offer that today. And I thank the gentleman from South Carolina, and I yield back.
Gentleman yield.
You can yield.
Yield to balance the time to Mr. Jordan.
I thank the gentleman for yielding. The gentleman from Maryland says we brought the Supreme. No, we didn't. March 14th on NPR, the gentleman from California said this. He hopes the hearing with Mr. Ross provides, quote, something the courts can use. We didn't say it. We didn't bring it up. You guys did. We're just highlighting the fact that you did bring it up. Once again, we have an amendment which simply states facts. Simply states facts. Did the court hear this case on April 23rd, 2019? Yes, they did. Will they rule sometime this month? Yes, they will. So now this is the second amendment. The majority, thank goodness the chairman's seen the light. But members of the majority, the second amendment, because we just had an amendment about an hour and a half ago where we had 3 facts. The fact that we've asked the citizenship question from 1820 to 1950. The long-form census asked it from 1970 to 2000. And the community survey from 2005 to present. So for 200 years, we've asked the question. And they didn't want that amendment either because we don't want facts in this resolution that we're going to pass. Can't have that. So this is just another statement of fact. The court heard the case. We didn't bring up the court. You guys did. You did it in a public interview for the whole world to see. The reason you had Mr. Ross in here was so you could get information that would influence the court. Plain and simple. And we're simply pointing out facts that we think should be in the resolution, and the majority says no. I yield back to the gentleman from South Carolina.
Let me say this, Mr. Norman. You yield back?
I yield.
All right. I think we need to get back to center here. You know, the rules of the House of Representatives adopted pursuant to the rulemaking clause of the Constitution established the Committee on Oversight and Reform as a standing committee of the House of Representatives. Just want us to remind you. And what it says is, under House Rule 10, the committee, our committee that is, has legislative jurisdiction over issues including population, demography generally, including the census, and the overall economy, efficiency, and management of government operations and activities. I want it, I think we really do have to kind of wall this off. And I do not want the court piece to be all up in this, because it's not about the court. It really isn't. It's about us trying to make sure that we do our job as a co-equal branch of government, no matter what. And as I've said, there's certain things that come to our attention that if we don't look at them, it is legislative malpractice. And so, again, I think we need to be careful. I don't want us to go too far afield. But I want us to zero in on what our job is, not what the court's job is, but what our job is. And so that's why I wanted to just remind everybody. I'm going to go to Ms. Tlaib, and then I'm going to come back to you, Ms. Maloney. Ms. Tlaib.
No, thank you, Mr. Chairman. I do have concerns about the amendment. I mean, in many ways, and I moved to strike the last word, but in many ways, it infers in some ways that we're deferring our responsibility and our duty. And this constant referral as if the United States Supreme Court, whatever actions that they're having, somehow coincides with our responsibility and duty. It doesn't. I mean, I think we are missing the center, Mr. Chairman, the people that are impacted by this. I represent close to 90% African-American community in the city of Detroit. 60% of my district is African-American. I bring this up because of this. I want to know what this memo by this political appointee at the Commerce Department named James Ottermeyer, I want that document, because this isn't about citizenship question getting on or not, whatever decisions are being made at whatever levels. This is about the intent by the current administration to not include communities of color who tend to vote align with maybe different perspectives or align different political parties. This is about not counting everyone that is in our country. This is a political motive. And yes, Mr. Chairman, I have to say to this fact, this is cheating in many ways an election. This is cheating by saying we don't want to count everybody. We want to count as less people as possible, and that impacts directly communities of color. So the less they count, they draw the lines so that people that are currently in power, maybe in those in the administration, have more power. The fact of the matter is a political appointee guaranteed a memo, which we know that James Ottermeyer printed a copy of this memo, walked it over to the Department of Justice. He didn't email it, he hand-delivered it. We have a right as this body to see that memo, to see what the intent here. Put the political debate or party, whatever, aside. This is about whether or not we as a country want to count every single person, no matter their status and so forth. But doing this is political motivation, this is very racialized. This is because you don't want communities like mine being represented here in this chamber equally. This is about that. And it really breaks my heart, honestly, to be in this chamber and talking about, well, this is what's happening, and oh, they didn't do this, and they didn't do that. No, remember that these are about people that have every right to be counted, every right to have access to opportunities based on whatever we do, maybe around education, healthcare, whatever it is. This is corruption at its core. This is political corruption when somebody outside of the agency, outside of the administrative rules, is telling people in this chamber, this is what we're going to do. We're going to put the citizenship question forward. Well, I'm sorry, I want to see the memo, Mr. Chairman. I have a right to see the memo. My district wants to see the memo. And maybe your districts don't. Maybe not. But majority of our districts want to see the memo. We want to know what this political appointee's true intent was. Is it really about citizenship? No. It's about reducing the number of people of color in this country being counted in the census. That's exactly what it's about. Because you want to cheat. He wants to cheat, Mr. Chairman. He wants to cheat this process. Well, not on our watch, and I will not defer my responsibility as a member of Congress to the United Supreme Court. 650,000 people depend on me doing my job here, and I will not support this amendment because I will not infer anything that says that my responsibility as their representative here in this chamber is taken away by supporting this amendment. Thank you, Mr. Chairman. I yield the rest of my time.
Would you yield to me?
Would you yield to me? Yield to me.
I will yield to Mr.
Thank you.
Chairman.
Let me ask you this. When you said somebody cheating, you were talking about Altmaier? I just wanted to clear.
Oh, I'm talking about political appointees that are outside, that are not, Mr. Chairman, we know that these are folks that we know for a fact. I mean, this is not the first time we're asking for information. April 2018, May 2018, we've asked specifically this information. And now we're at this point where we're obviously putting forward a contempt. This is about the political appointee at Commerce. Before the so-called, before he comes over and I remember this moment where he says, well, no, Department of Justice asked me to put the citizenship request. No, there was some dialogue and conversation, political gamemanship that's happening behind closed doors. And they were cheating the administrative process. They were cheating us, the American people, of knowing exactly what their true intent is.
I yield back, I think. Do you finish?
I really hope so.
Okay.
I really want to vote on this. I really want the information.
Yeah,
Mr.
yeah.
Chairman, you know how passionate I am about this.
I feel it. I feel it all up in here.
Mr. Chairman, my father went up to 4th grade education, my mother 8th grade, just similar to you. And Mr. Chairman, I know my mother has been a U.S. citizen for almost 42 years. But you know what's going to make her hesitate? Is when they ask her about that in her question. It's going to make her hesitate, even though she's been in this country for 4 decades. And we all know that's exactly their true intent here.
The gentlelady's time has expired. Okay, Lori. Ms. Maloney. Ms. Maloney.
Thank you, Mr. Chairman. I would like to return to the purpose of this hearing today. The votes that we'll be taking here today on criminal and civil contempt of Congress for Secretary Ross and Attorney General Barr. And these votes are not taken lightly by the chairman or anyone else on this committee. But in my opinion, they are justified in every moral, practical, and constitutional sense. Since Secretary Ross decided to add a citizenship question to the census, this committee has worked diligently, tirelessly, to determine the real reason for adding the question that experts, one after another, believe could result in an undercount of 6.5 million Americans. That's not me talking. It's not Democrats talking. This is independent researchers, analysts, saying adding this question will be an undercount. And on top of it, 3 federal judges have ruled that adding this question, that Secretary Ross violated federal law, the Constitution, or both. And while the committee conducted its constitutional duty, our requirement, on behalf of the American people, we requested documents, we had interviews, we had hearings, we asked for witnesses, we asked for more information. Why do you want to add a question that experts say are going to result in an inaccurate census that won't be counting all of us? And we gave Secretary Ross and AG Barr numerous opportunities to show a single ounce of good faith and cooperation. But the current administration resisted at every single turn, at every single request, with outright refusals to cooperate, even with bipartisan, and I want to underscore, bipartisan subpoenas issued by this committee requesting information. They have yet to comply with the subpoenas this committee approved more than 2 months ago. And now we're up against a deadline. The census forms are set to go to print at the end of the month. We no longer have the luxury of giving the administration more and more and more time as they refuse to give us the information we justly requested. This administration's continuous stonewalling of all of our oversight's efforts is a direct threat to the rule of law. It is the definition of criminal contempt of Congress and, by extension, contempt for the American people. The behavior of Attorney General Barr and Secretary Ross make it clear that they are desperate to hide their improper activities. With each new piece of information that is uncovered, we see that they indeed have a great deal to hide. The administration has repeatedly misled, mischaracterized, and misrepresented the truth. The first misrepresentation, and I'm being generous when I call it a misrepresentation, was when we were told that this question was needed to better enforce the Voting Rights Act. Secretary Ross misrepresented and covered up further when he told us that he responded solely to the Department of Justice's request for the question for that purpose. Now we know that that is untrue with information we've seen. Secretary Ross personally asked Attorney General Sessions to get DOJ to cooperate in requesting the question. And 2 weeks ago, we finally learned the real reason why Secretary Ross and the administration were willing to break federal law and violate the Constitution thanks to the courage of one patriotic woman and the sharp eyes of pro bono attorneys. While going through her deceased father's belongings, a brave woman discovered evidence that explains the origins of this unconstitutional question. Her father was a Republican strategist named Thomas Hoffler, who had a reputation and was called the Michelangelo of gerrymandering, who wrote a blueprint on voter disenfranchisement. In 2015, he wrote a study concluding that adding the citizenship question to the census would create an undercount of minority voters.
Time has expired.
Okay. Every American should read his memo.
The gentlelady's time has expired.
Okay.
Thank you.
Mr. Chairman, I have a unanimous consent request.
What is it? Go ahead.
Say public decision memo from Wilbur Ross in which it states that the department and the Census Bureau's review of the DOJ request with all significant census assessment prioritize the goal of obtaining complete and accurate data.
Without objection, so ordered.
Thank you, sir.
Mr. Chairman?
Mr. Chairman?
Mr. Chairman? Oh.
Come on.
Mr. Chairman?
Go ahead.
Thank you. I just wanted to make sure, and speaking on this amendment again, and while I respect the intent of trying to acknowledge the historic moment and the historic ruling that is before us and before the Supreme Court, I want to reiterate the sentiment that Mr. Raskin and Ms. Tlaib expressed, because there is a reason that our government is designed the way that it is, and it is because it is designed to acknowledge the flawed human nature in our grand experiment of self-governance. Unspeakable horrors have been executed by the United States in the name of citizenship, in the name of determining who is a citizen, and by citizen we mean who is a person in our democracy. That is what citizenship means. It is an acknowledgement of personhood in American democracy, an acknowledgement of power. And when I think about Supreme Court decisions with this, I think about Dred Scott. I think about Korematsu versus the United States, where the Supreme Court upheld Japanese internment regardless of the citizenship status of Japanese Americans. And how did that start? It started with the United States Census. Started with the United States Census. We have laws on the books saying that information from the census cannot be used in any other way, that it must be confidential. And what happened? When the federal government, the executive branch, the president of the United States, I don't care if he was a Democrat, I don't care if he was a Republican, it was wrong. And what he did, he asked for information, and the Census Bureau broke the law and divulged information on zip codes where Japanese Americans were concentrated. And that information was used to intern American citizens and non-American citizens alike. And the Supreme Court upheld that. Dred Scott, a black man suing for his freedom, came right before the United States Supreme Court. And what they said was that the U.S. Constitution did not give African American citizenship. They have gotten it wrong. The Supreme Court has gotten it wrong. And unspeakable violations of human rights and civil liberties have been executed by the United States government in light of that. And I can tell you, with this Supreme Court argument, they could very well get it wrong again. And I don't even want to think about how far that could be pushed. But that is not even what the question is at hand today. Because what this subpoena is about and what this contempt is about is the fact that we have asked for information and there is a refusal to comply with a co-equal branch and our power. That's all that this is about. That's all that this is about. And so we have to execute our power and hold that power to account and vote on contempt. So the reason I do not want to support this amendment is because I don't want to muddy our waters. I want to make sure that we are laser focused, that we are effective, that we are efficient, that we don't add any bloat and we do not confuse people as to why we are doing what we need to do. We are voting on contempt because we need to do our jobs and people are refusing to comply and because we have given no choice, regardless of what's being held in front of the Supreme Court, regardless of what's happening in the executive branch. We need to do our job, and that is what this vote is about today.
Gentlelady yield.
Will the gentlelady yield?
Yes, I'll yield to the chairman.
Your statement about the Japanese internment camps is so real. I don't know if you noticed, there's an article in the paper today, I think it is. It says that the Trump administration is now using those same camps to put immigrants and people trying to get into our country, and children. And I just wanted to say that when I listened to Mr. Raskin and I listened to our arguments, and then I heard Mr. Jordan say, he suggested that the true purpose of the amendment is to be able to argue that we are interfering with the Supreme Court. I don't want that muddled either. I want our committee to do what our committee is supposed to do. I want our Congress to do what it's supposed to do. And I want to preserve the power that the Founding Fathers gave us in their wisdom. I do not want it diluted. I don't want it power light. I want the full power that the Congress is supposed to have. And so I'm not going to be supportive of this, okay? Who else? Who's next?
Chairman Cummings?
Mr. Uda.
Thank you. I'd like to speak to a few things. I'm a freshman. I had never run for office before coming here. And my message was that most Americans are between the 20-yard lines, that we have a lot more in common than what separates us. And one of the most poignant moments in my journey here was when I raised my right hand with my eyes welling up and taking an oath to the Constitution of the United States of America. And in taking that oath, we're not taking an oath to a party. We're not taking an oath to a president. We're taking an oath to uphold the Constitution of the United States of America. And I take the issues we are facing here today and appreciate the enormity when we are contemplating this resolution with Secretary Ross and Attorney General Barr. And I wanted to study and look and try and find information and support as to where I should land on this. And I also wanted to look at the pros and cons of what I see as the major issues. with the first major issue that we seem to be talking about a lot is executive privilege. And I don't think anybody in here thinks that the White House and the administration have absolute, unbridled executive privilege, that there should be limitations on the exercise of executive privilege. And in fact, I actually agree with the chairman of this committee who said the executive branch has executive privilege. It's narrow, it's well-defined, there is case law. If you do not find a legitimate basis to deny us material we've asked for, we will seek the remedies necessary to compel. And I can't agree more with past Chairman Issa and the Republican side of the aisle in making that statement. I agree. Those are appropriate statements regarding executive privilege. I also take exception with the ranking member's comment about the Democrats, why don't we want to know who is a citizen? The reason is because we already know. We already know through administrative functions such as Social Security who has citizenship in our country. But don't take my word for it. The Census Bureau's chief scientist under the Trump administration, Dr. John Abowd, wrote to Secretary Ross that, quote, adding a citizenship question to the 2020 census is very costly, harms the quality of the consensus count, and would use substantially less accurate citizenship status data that are available from administrative sources. But don't take his word for it. 6 former Census Bureau directors who served in both Democratic and Republican administrations sent a letter to Secretary Ross opposing the addition of the citizenship question. We also seem to be taking a lot of time talking about the volumes of pages that have been delivered to the committee. They've been non-responsive. This is no different than receiving a book from Amazon that you didn't ask for and them telling you to read it instead of the one you ordered. We deserve to have the documents we have requested given to us. There was a statement that this is a vast and nefarious conspiracy in the belief of Democrats. For me, nothing could be further from the truth. I do not think this is a vast and nefarious conspiracy. I think it's a nefarious group of individuals within the administration who are trying to do harm to our census, which leaves me thinking that the Speaker said it correctly. No Justice Department is above the law, and no Justice Department is above the Constitution, which each of us has sworn to uphold. I could not agree more with Speaker Boehner when he uttered those words. The question I'm always asked as a freshman is, what's the biggest unexpected thing you have come to see in Congress? And for me, it's the hypocrisy. It is the hypocrisy when we have all taken an oath to the Constitution. And that oath should stand firm. It should not be swayed by political winds, by polling, or who is in office. That oath must stand firm. And I would ask that all members in this body reflect on staying true to the oath you took, regardless of the party in power. Thank you. I yield back.
The question now occurs on the amendment offered by Mr. Meadows. All those in favor signify by saying aye. Aye. All those opposed, no. No. The noes have it.
Take a roll call.
Roll call. We will suspend the vote until the roll call until we take all the other votes. Yes. Yeah, it's an amendment in the desk. Mr. Gibbs. Let's pause for a second and get it distributed.
An amendment to the amendment in the nature of a substitute offered by Mr. Gibbs of Ohio.
Thank you, Mr. Chairman. This is just really a simple amendment that I think should be included in the resolution. So when we talked a lot about historians, but how about the average American? When this amendment passes out and then when they read the resolution, when the resolution passes out, they see what's in it. And I think it's important that we documented some facts. The fact that the Attorney General has produced over 17,000 documents in response to the April 2nd, 2019 subpoena. The fact that the Deputy Assistant AG, John Gore, voluntarily appeared before Chairman Cummings at his request for a transcribed interview to March 7th of this year. And I think it's just important for the average American who reads the resolution to know the other side of the things that happen and have that transparency and to show that the administration has been forthcoming on some of these requests. And I think it's good for the historians, but also for the average American. And I urge all of my members of the committee to support this amendment. That's just to document the actual facts that's happened, and it'll be part of the record in the resolution.
I disagree with this amendment. It basically it's not accurate. The responses that we've gotten have not been responsive. As has been stated already, most of the material was redacted. A number of pages, I mean, I can't countless, quite a bit of it was already in the media. And the very things that we really wanted, we have not gotten. And we've asked for it over and over and over again. And so I would oppose the amendment. Yes, Mr. Sarbanes.
Thank you, Mr. Chairman, for yielding. Yeah, I oppose the amendment as well. I mean, if you look at these sort of two-sentence amendments we've been getting over the last few hours, they strike me as attempts to kind of normalize bad behavior. And we're not going to be complicit in that kind of a narrative here. I mean, we had the Supreme Court one. That's kind of a distraction because, as was pointed out compellingly, that's really irrelevant to what we're doing here. We had this thing about when and how the citizenship question has been presented in the past, which is sort of to make it look like it's harmless to put it in there when we know that it can be extremely harmful. And then this latest amendment, which again tries to just kind of normalize everything that's going on. I want to play it as straight as possible here. There's two real sources of anxiety I think we have. The first just has to do with the question itself. So forget about the motivations for a moment. We have evidence, we have expert testimony, that if you put that question on the survey, on the census survey and questionnaire, it's going to have an impact of an undercount in the millions. And we know how important it is to get an accurate count. I think some of these statistics have already been quoted in the hearing, but I'll restate them if they haven't been. 320 federal programs relied on census data to distribute over $880 billion in federal funds in FY 2016 alone. 55 of those went directly to rural communities. And the federal government distributed over $30 billion specifically to rural areas in fiscal year 2016. Then we could show the impact on urban communities for not getting these counts right, on school systems who depend on the Title I formula for the funds that they get, as to why it's so important to get the number right. So even just leaving aside whether you had concerns about the motivation behind the question, putting that question on there, there's just absolutely no question the impact it will have. And it's our responsibility to make sure that the people are heard, that their power is represented through the census. So that's one legitimate source of anxiety that I think we're bringing to bear. The second is the concern over motivation. Because the evidence, and this is why we're trying to get more, the evidence is that the Trump administration is actually looking to weaponize the citizenship question for political gain. That's the deepest anxiety. And then you put the two together. You know the impact it will have based on what the experts are telling us if you include that question. You then have enough evidence and suggestion that the motivations behind putting the question on there are insidious. You put those two things together, and no wonder we're as concerned as we are. No wonder you're taking all the steps you are to try to get to the bottom of this and get good information. Because Americans need to be deeply concerned if there's a campaign underway to take this question, weaponize it in a way that is designed to diminish the power, the presence, the voice of certain communities across this country. And all we're asking is we want to get to the bottom of it to make sure that we're doing our duty and fulfilling our responsibilities to the people of this country that we are asked to do every 10 years as part of this census. So that's playing it as straight as I possibly can in describing why we have the anxieties we do, and I'll yield back.
Gentlemen yield to me. Let me just say this, Mr. Sarbanes. This morning when I left Baltimore at 5:30 coming to D.C., I saw people getting the early bus. They were the maids. They were the people who take out the trash. They were the janitors, the restaurant workers. And, you know, I said to myself, you know, when they get their stub at the end of 2 weeks of the paycheck, they see a lot of taxes taken out for them. And the least we can do is make sure that they get what they are due. In other words, making your point, when it comes to the census, if we don't get it right, that means that they are being denied the very funds that they have put out there, and they need it the most. Needed the most. So, and we're talking about 10 years. It's not a year, it's 10 years. That kid that was 1 year old now, in 10 years is 10. That's a lot of years. And a part of that kid's life being deprived of those things that we're talking about, education, healthcare, all of that, they're denied. And that's why you're right. You're absolutely right. We have to get it right. We got to do it. Who's next? Question now occurs on the amendment offered by Mr. Gibbs. All those in favor signify by saying aye. Aye. Those opposed, no. No. The noes appear to have it. We will record that vote later.
Mr. Chairman,
Yes.
I have an amendment. Mr. Chairman.
Who are we going to do? Their side or our side? Gomez.
Thank you, Mr. Chairman. I feel like people forgot how to take turns around here.
You have an amendment?
I'm in support of the amendment. And the reason why is that the census, as everybody mentioned, is a big deal. It's been used throughout our history to either empower or to marginalize communities because it has an impact on apportionment, government resources, you name it. It is the fundamental building block of our country. So what we're trying to discover is, did this administration decide to marginalize or empower? I believe it's marginalized. And because of our investigations, they have started a strategy of dodge, delay, and deceive. They dodge questions when they come before our committee. They delay providing documents or witnesses to when we ask for them. And then they deceive Congress and the American people about the true intentions and motivations of adding this question to the census. Yes, I know. Originally, we were told that the Department of Justice wanted more census block data on citizenship so they can enforce the Voting Rights Act. But yet, the Voting Rights Act has been enforced since 1965 without a problem. Now it's an issue. highly unlikely. And later, we discovered it wasn't the DOJ making the request originally. What they did is Department of Commerce went and asked DOJ to submit a request to add the citizenship question, but they didn't respond. So they went to other departments trying to get them to ask. So if it was really the Department of Justice asking for it, then why are you shopping around for departments that will enforce and actually do your dirty work? So when we keep looking at it, it just shows that there's something not right in their arguments. And when it comes to the last amendment, they basically used John Gore came before the committee on March 7th. Well, he didn't answer not one question, not two questions. He refused to answer 150 questions before the staff. 150. If you're an open book, then why are you dodging so many questions? Because that's what they want to hide their true motivation, right? Let's go back. Last week, the committee staff released a memo describing our transcribed interview with Chris Kobach after the Department of Commerce accused Chairman Cummings of lying. But the memo was accurate. The memo described how Mr. Kobach, who is a GOP voter suppression specialist, had proposed a draft citizenship question to Secretary Ross and explained his rationale. He wrote, "The lack of a citizenship question, quote, leads to the problem that aliens who do not actually reside in the United States are still counted for congressional apportionment purposes." Secretary Ross testified before this committee that he, quote, rejected the question that Chris Kobach wanted. But Mr. Kobach had a different recollection. In his interview with the committee staff, he said that about Mr. Ross, Secretary Ross, quote, "Well, I don't recall what he said. I could say this. If he had said flatly, no, I don't, whatever, I think that's a bad idea. I probably would have remembered that. So I think and I don't remember his specific response, but I'm pretty sure it wasn't, absolutely no." Well, that's pretty clear. Of course, Secretary Ross ultimately did add a citizenship question, and that question matched the one used on the American Community Survey and differed only slightly from the one Mr. Kobach proposed. Let me show you the two versions of the question up on the screen. Well, once they get it up.
Come on, you guys.
Nope. Well, my point is, if the department has nothing to hide, it's a simple way of proving it. Stop withholding documents. Stop doing the dodge, delay, and the deceive, because we know where this will end up. The folks on the other side of the aisle, my Republican colleagues, say it's all about history. And I want to tell them something very clearly. History will show that they're on the wrong side of this issue. Simply enough. And with that, I yield back.
Mr. Chairman,
Gomer,
I have an amendment at the desk.
please distribute the amendment. Sorry, man. Mr. Gomer, please speak.
Thank you, Mr. Chairman. This is a simple amendment that basically states the fact that the Secretary of Commerce has produced over 14,000 documents responsive to the April 2nd subpoena, including on June the 3rd. We can be very clear, the Commerce Cabinet has made 2 senior officials and 1 former official available for voluntary transcribed interviews, including one yesterday. The Commerce Department and Justice Department have produced over 31,000 pages of documents, including a document production from Commerce on June 3rd. And there's also already an extensive public record of the issue from the Commerce Department's decision-making process and the various lawsuits that liberal special interests have brought. Mr. Chairman, I could go on and on with other facts that I think everyone on the committee knows, including the fact that the Trump administration has produced already over 93,000 documents for 2019. But for the sake of time, I would just move approval or adoption of my amendment, basically stating the facts of what the Commerce Cabinet has done to comply with this committee's request.
I'm vehemently against this amendment. The question now occurs on the amendment by Mr. Comer. Mr. Comer?
Yeah.
All those in favor signify by saying aye. Aye. Those opposed, no. No. The noes have it.
Mr. Chairman, I ask for a recorded vote.
Very well. We will postpone that until later.
The vote now occurs. Yeah, the vote now occurs on final passage. Well, you didn't tell me that. Sorry.
There being no further amendments, recorded votes on the pending amendments have been postponed. Once those votes are taken, the committee will immediately consider the motions to adopt the amendment in the nature of a substitute as amended, if amended, and report the measure.
Now we'll go to the next bill. We're going to the next bill.
Mr. Lynch.
Mr. Chairman?
Mr. Lynch.
Mr. Chairman?
Yes.
Down here.
Oh, okay, yes.
I was waiting to strike the last word on the contempt bill.
All right.
Let's recognize her out of order.
All right.
I mean, I don't need to jump in front of Mr. Lynch.
Go ahead. Go ahead, please.
Are you sure? I just wasn't sure where we were in the
No,
order.
go, please.
Okay, thank you. Thank you, Mr. Chairman. This administration consistently has seemed to think that following the law has some kind of optional drop-down menu that allows them to pick and choose when they follow it. Heeding Congress's requests for information is not optional. Today is really all about there being consequences to those actions, because no one is above the law. Subpoenas are not optional. The Constitution is not some real estate contract the president can treat like it's not worth the paper that it's printed on. This committee has worked painstakingly to get answers regarding one of the most fundamental components of our democracy, the U.S. Census. We must get to the heart of why, after 70 years, this administration, 70 years, would add a question to the census asking every American whether they are a citizen. I don't need to reiterate what every member of Congress in this room knows. This question is untested, unnecessary, and will result in a less accurate census. In fact, earlier in this hearing, I underscored that the reason the Census Bureau discontinued use of a citizenship question is because it contributed to an undercount, the exact opposite of the goal of having a census required in the United States Constitution in the first place. In fact, we recently learned that it is very likely that producing a less accurate census is exactly the administration's goal. Recent court filings show that Republican gerrymandering expert Thomas Holfeller, as we've heard, advised this administration that adding this question would, quote, be advantageous to Republicans and non-Hispanic whites. The goal is clear: undercount immigrants, undercount communities of color, and deny fair funding and representation to the communities in which they live. This is quite simply a diversion of democracy. This administration is working to weaken communities like Miami-Dade County and Broward County, both counties which I represent, to ensure they have less political power and less federal funding for our schools, roads, and other public services. Including a citizenship question turns the U.S. Census into a tool of marginalization, when it should be a bastion of representative democracy. This administration has failed to produce requested documents, defied subpoenas, and interfered with this committee's investigation in a coordinated effort to avoid transparency. And Secretary Ross sat here and lied to us, straight up lied to us when we asked him direct questions. And even with the redacted, ridiculously blacked out information we've received so far, that is clear. The Trump administration may be abdicating their duty to serve the American public, but this committee is not. And we will vote today to uphold the sanctity of our nation's laws and seek to avoid the manipulation of a sacred constitutional foundation of our democracy. To be counted. Thank you. I yield back.
Will the gentlelady yield? Oh,
Yes, my time was not expired, and I do yield.
thank you. I wanted to make 2 points. One is that all of us in politics like to win. I've noted that it's kind of in the general personality type of people going into politics that people are kind of competitive. They like to win, okay. But I've asked myself the question, would I seek to win an election, Mr. Chairman, by suppressing the vote, by purging voters from the rolls? I went up to Ms. Ocasio-Cortez's district and to Ms. Maloney's district. We had a hearing of the Civil Rights, Civil Liberties Subcommittee up there about the census. And while the Secretary of Commerce is involved in this whole business about trying to paste a citizenship question on the census that didn't go through any of the normal channels or administrative process, he's neglecting the real duty in his job, which is to see that the census actually works. And people don't know about it. And so I think everybody on this panel, everybody in Congress should ask the question, does victory mean that much that we would actually risk undercounting the American population by 6 million people? Does it mean that much to us? I yield back to the gentlelady.
Thank you very much.
Thank you. I yield back, Mr. Chairman.
Now, pursuant to notice, I call up H.R. 391, the White House Ethics Transparency Act. The clerk will report the bill which was distributed in advance.
H.R. 391 to provide transparency regarding waivers granted to individuals from the ethics requirements of Executive Order 13770 or any subsequent similar order, and for other purposes.
Without objection, the resolution is considered read and open to amendment at any point. The chair recognizes himself to offer an amendment in the nature of a substitute. Copies of the amendment have already been distributed and are on the dais. The clerk will report.
Amendment in the nature of a substitute to H.R. 391 offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered read and will serve as the base text for purposes of amendment. I now recognize Mr. Lynch for 5 minutes.
Thank you, Mr. Chairman. As the sponsor of H.R. 391, the White House Ethics Transparency Act, I'd like to thank you for your work in moving this legislation forward. I'd also like to thank Representative Sarbanes of Maryland for including the text of my legislation into H.R. 1 for the People Act, the extensive campaign and ethics reform package that passed the House in March. In the interest of maximum transparency in government, H.R. 391 would require that the Trump administration and all future administrations to promptly disclose all waivers of executive branch ethics pledges that every political appointee is required to sign as a condition of their employment. The bill would require any executive branch official who issues a waiver when potential or actual conflicts of interest arise to provide a copy of that waiver to the Independent Office of Government Ethics within 30 days. It will also require the public posting of the waiver on the Office of Government Ethics website and the website of the issuing agency. Given the absence of timely and complete information on waivers issued by the current administration, the bill is retroactive to January 20th, 2017. During Democratic and Republican administration alike, executive branch ethics pledges have been put in place to better ensure that the important work that senior officials perform in the White House and other federal agencies on behalf of the American people is not controlled by the undue influence of private industry, previous employers, or foreign government lobbying interests, where waivers are issued allowing key personnel to depart from their binding ethical commitments and participate in matters that, as former lobbyists, industry attorneys, or consultants may present significant conflicts of interest. It is the fundamental right of the public to know that those conflicts exist and when and why the waiver was granted. The current ethics pledge was established by President Trump himself by Executive Order 13770 in January of 2017. Common sense dictates that the administration that has pledged to, quote, drain the swamp, close quote, would make every effort to avoid industry influence and welcome every opportunity to inform the American people about who precisely is working behind closed doors in the government. Regrettably, that has not been the case. According to the public interest investigative organization ProPublica, President Trump had already hired nearly 200 former lobbyists in the first year of his presidency. They included Lieutenant General Michael Flynn, who performed extensive lobbying work to advance Turkish government interests before his tenure as National Security Advisor. In March of 2017, a spokesman for the Lieutenant General confirmed that, quote, he never had an opportunity to sign the ethics pledge, close quote, during his 24 days on the job. That same month, he retroactively registered with the Department of Justice as a foreign agent. Yet, despite the steady influx of special interest personnel into the executive branch, the Trump administration initially blocked all requests by the Ethics Office to disclose its waivers at all. While the White House has since committed to providing waiver information on its website, it has remained resistant to the ethics transparency by failing to disclose waivers in a timely manner, issuing vague blanket waivers to groups of ex-lobbyists, and releasing waivers that are undated, as reported by the nonpartisan government watchdog organization Citizens for Responsibility and Ethics in Washington. The absence of dates raises the serious concern that some waivers may have been granted retroactively. That's after officials had already worked on matters involving their former clients or employers. The White House last updated its public list of ethics waivers nearly 5 months ago. As a result, we still don't know the full extent to which waivers have been granted to key White House officials, such as senior advisor to the President, Jared Kushner, whose financial interests and previous private sector employment would seem to present a myriad of conflicts of interest with his White House portfolio, as detailed in the recent Majority Staff report on the administration's efforts to rush the transfer of nuclear technology to Saudi Arabia. Mr. Kushner's family's company received a significant cash infusion in August of 2018 when Brookfield Asset Management agreed to pay the rent up front on a 99-year lease for the Kushner family's debt-ridden 666 Fifth Avenue project in New York. Only a few months prior to the deal, which the New York Times characterized as removing the family's biggest financial headache, a Brookfield subsidiary had announced its plans to purchase Westinghouse Electric for $4.6 billion. Westinghouse is a bankrupt nuclear services company that stands to significantly benefit from the developments of nuclear reactors in Saudi Arabia. In his executive order on ethics, President Trump acknowledges that the political appointees are, quote, invested with the public trust, close quote. By requiring the administration to timely and publicly disclose all waivers allowing the president's appointees to bypass executive branch ethics pledges, we will be able to better preserve the faith of the American people that their government is working for them rather than outside interests. So I urge my colleagues to remember this is important to our collective oversight responsibilities. Someday, I'm just reminding my Republican colleagues, someday there'll be a Democratic president. And at that moment, I'm sure you will rediscover your obligation to conduct oversight. This change will help the oversight function of this committee. I urge my colleagues on both sides of the aisle to support H.R. 391, the White House Ethics Transparency Act. I thank the chairman for his indulgence, and I yield back the balance of my time.
Yield to the gentleman, the ranking member, Mr. Jordan.
Thank you, Mr. Chairman. H.R. 391 is word for word from H.R. 1, We asked for a markup on H.R. 1, but the chairman said no. Today, we shouldn't pretend, after we've already voted on H.R. 1 on the House floor, that we're going to go through regular order. But here we are again, marking up parts of H.R. 1. Politicizing and weaponizing the Office of Government Ethics means creating another way for Democrats to attack the Trump administration. And that's exactly what this bill before us today does, targets the current administration. President Trump's executive order, number 13770, requires every presidential appointee to sign an ethics pledge. Appointees can obtain a waiver for any restriction contained in the pledge. H.R. 391 would require these waivers be posted on the employing agency's website and the Office of Government Ethics website. Making these ethics waivers publicly available is a good thing, good for government transparency. However, this administration already makes these ethics waivers available. This bill is clearly not about transparency. This bill is about targeting the president and his administration. H.R. 391 requires previously issued waivers be made publicly available, but not all previously issued ethics waivers. The bill only requires transparency for ethics waivers issued since January 20th, 2017. Imagine that is right. The retroactive applicability of the bill highlights the true intentions Democrats have for this legislation. Let's only get this information for the last 2 years in this administration. Seems to me, if we're going to pass this, let's just pass the bill like any other bill. It'll become law, and then it's applicable to this administration as it moves forward and any other administration that's going to be in office in the years to come. Or we can make it retroactive for everyone else. But no, no, no. Just since January 20th, 2017, this bill is yet another tool to harass the president. I urge my colleagues to oppose the legislation.
Mr. Chairman.
And I yield back.
Mr. Raskin.
Wait, could I just say, President Obama voluntarily posted ethics waivers that were issued under his executive order, so they're already available. But
so is Mr. Trump.
Do I take the gentleman's point to be if we make it fully retroactive, going back through the Obama administration or back to the beginning of the ethics laws, that he would support the bill? Because in that case, I would amend to do it.
I think we should do legislation like we're supposed to. I assume the gentleman's asking a question that we should do legislation like we're supposed to. We pass a law. It is then the law, not retroactive, but the law from that point on. And as you point out, the Trump administration is also making these available.
Yield back. Yes, I'll yield to the gentleman from Massachusetts.
I thank the gentleman. So it was, just so the gentleman, the ranking member, is painting this as a Democratic versus Republican thing because there's a Republican in the White House. But I want to, I ask unanimous consent to submit a letter from Senator Charles Grassley of Iowa. And it is in this letter dated June 11, 2009, that Senator Grassley urged the White House to make, and at that time, the Obama White House, to make transparency and ethics waivers and recusals public. So this is exactly what we're trying to do with the Trump administration. The difference here is that when President Obama got the request, he responded to it and made them public. That's not what we're seeing from the Trump administration. His last posting was incomplete. It was back in January, 5 months ago, and we still have individuals in the administration that we know have conflicts, but yet there's no waiver indicating that they have been allowed to engage in the activity they're currently engaging in. So that's the difference, that Obama made it public, he posted it, it was uniform, it was widespread, and he was accountable. The Trump administration is not doing that.
They are making him public. They're posting him too.
Well, the gentleman,
No, reclaiming my time.
You didn't yield your time.
Right. So here's the deal. They're not disclosing the individuals. They're just saying groups of employees
without naming the individuals, have been given a waiver. They're also undated, so they go retroactively, I guess, back and give waivers to people who have already been lobbying in the area where they used to be employed. And the Kushner situation is really troubling because he has a portfolio that covers Saudi Arabia, Qatar, and other countries in the Middle East. His family's business was at the verge of bankruptcy. A Middle East company comes in and basically prepays the lease. So they get a 99-year lease on the Kushner family property at 666 Fifth Avenue, and they prepay the lease for 99 years up front and bail out the Kushner family's property.
Would the gentleman yield?
Sure.
I'm looking at the list now from this administration. James Ayers, Michael Candazzaro. Here's a name you probably know, Pat Cipollone.
Where's Kushner's name? Could you start with that one?
Does Kellyanne Conway work for the White House? You said there was no individuals
No,
named.
no. I said it's incomplete. And I don't see Kushner's name
Daniel
here anywhere.
Epstein works in the White House counsel's office. Pat Cipollone runs the White House counsel's
Reclaiming
office.
my time. I don't see Kushner's name here. I don't see it. He's a special advisor to the president on Middle East affairs. He's also receiving direct benefit. And by the way, he didn't divest himself of his interest, his direct interest in that property that's now being bailed out.
Gentleman yield?
Not at this time, no. I yield to the gentleman from Maryland, Mr. Sarbanes.
Thank the gentleman for yielding. I thank you for the legislation. I just want to step back a little bit because if you look at many of the ethics reforms that are contained in H.R. 1, and this was one of them, what they were recognizing is a situation where things that had become norms were being ignored by this administration. Things we never thought we would have to codify, requirements, expectations, guidelines, rules that prior administrations had abided by, had met kind of the expectation of public around, et cetera. Those were being ignored. So a lot of what you see in the ethics reforms that are part of H.R. 1 are really designed to codify what the public expects should be the guidelines. And this is just another example of that. I mean, it's common sense. We want to know if there's any conflicts of interest so that we know whether the administration is acting in the public's interest or on behalf of special interests. If there's waivers that are granted from that policy, that conflict of interest policy, the public needs to know that too, or else the fix could still be in. So that's why this legislation makes sense. I yield back my time.
The representative, let me just yield myself a few minutes. Representative Lynch is the chairman of the Subcommittee on National Security, introduced the White House Ethics Transparency Act in January. This bill is included in H.R. 1. This bill would require that ethics waivers issued to political appointees under President Trump's ethics executive order be publicly available. I think the American people are crying out for transparency and accountability. President Obama voluntarily posted waivers issued under his ethics executive order on the White House website. The Trump administration initially refused to release the waivers issued under the President Trump's ethics executive order. On August 1st, 2017, Senators Gary Peters, Charles Grassley, and Dianne Feinstein sent a letter to the White House that said, and I quote, "We expect the administration to make these waivers publicly available as they are granted." Yielding to public pressure, the Trump administration disclosed waivers issued at the beginning of the administration, but the White House has not consistently posted new waivers. This bill is about transparency and accountability, and I strongly support it.
Mr. Chairman.
I yield to the gentlelady.
Thank you.
Ms. Watson.
When you're ready, I'd like to strike the last word. Thank you. You know, Mr. Chairman, I think it's imperative and entirely reasonable to want to know exactly how many White House employees the Trump administration has decided to do not have to comply with our ethics laws. That's what this is about. I don't know that. This committee doesn't know that. The Office of Government Ethics doesn't even know that. Why? Because the Trump administration refuses to provide comprehensive details about the waivers that it's issued for employees of the White House or the Executive Office of the President. The handful of waivers the White House has made publicly available lack key information. I mean, the representations that are being made by our friends on the other side of the aisle seem to think it's acceptable to just pick and choose what pieces of information you provide and deem that transparency. That should be deeply troubling to every person sitting in this room. I mean, I would think that we would want to know what potential conflicts of interest there were in the White House by people who are making decisions every single day that could affect their own personal bottom line, that they might be ethically compromised in making. When the White House issues an ethics waiver to a White House or executive office official, the American people should know who received that waiver and why they received it. All this bill does is make a common sense change. It should be wholly uncontroversial. We shouldn't have to pass it because the law already requires all of this information, and the administration appears to just be willing to ignore it with impunity. Again, our ethics laws are not optional guidelines, just like the Constitution isn't optional, just like federal law is not optional to comply with. These policies are in place, these guidelines are in place to stave off corruption and identify compromising conflicts of interest. And I'll say this, the administration certainly has been keeping the Office of Government Ethics busy. Mr. Chairman, the American public deserves nothing less than full transparency about the officials whose salaries are being paid and with taxpayer money and whose policies are impacting Americans' lives. I urge my colleagues to support the bill, and I thank Mr. Lynch on his leadership on it.
Would my friend yield?
I'd be happy to yield.
I thank my friend. I just want to say I associate myself with the remarks, and I think we need to be real clear. What's going on here is not quibbling about how much, who, or when. It is about the complete untethering of the White House with Mr. Trump's enablers here in Congress of any accountability. That's really what's going on here. And on our side of the aisle, we are fighting to restore accountability and the legitimate form of our government in terms of the role of the legislature. And so let's not have any illusions about what really is going on. And that's why I'm happy to support the measure in front of us, and I hope all of our colleagues will join us. And I thank my friend for yielding.
It's my pleasure, and I yield back the balance of my time.
There being no further discussion on the amendments to the resolution, the question now occurs on the adoption of the substitute amendment offered by the chairman. All those in favor shall signify by saying aye.
Aye.
All those opposed, no.
No.
In the opinion, the ayes have it. The ayes have it. The amendment is adopted.
So the substitute amendment is, and then we'll report it to the House. They will want to record a vote on reporting it to the House. So we can vote on reporting it to the House. All those in favor of reporting it to the House?
Now, pursuant to notice, I call H.R. 2003, ensuring the FEHBP coverage during Shutdown Act. The clerk will report the bill, which was distributed in advance.
H.R. 2003, to amend Title V United States Code to clarify that during a lapse in appropriations, certain services relating to the Federal Employee Health Benefits Program are expected services under the Anti-Deficiency Act and for other purposes.
Without objection, the bill is considered read and open to an amendment at any point. The chair recognizes himself to offer an amendment in the nature of a substitute. Copies of the amendment have already been distributed on the dais. The clerk will report.
Amendment in the nature of a substitute to H.R. 2003, offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered read and will serve as the base text for the purposes of amendment. I now recognize myself for 5 minutes. I thank my colleagues Jerry Connolly and Mark Meadows, the chair and ranking member of our Government Operations Subcommittee, for working with me on a bipartisan basis to introduce this very important bill. We were troubled by recent reports of federal employees unable to pay for medical costs associated with the birth and treatment of their newborn children because they could not make a change to their health insurance due to the recent 35-day government shutdown. For example, on January 10th, 2019, Senator Smith read a letter from a constituent who was a furloughed federal employee, which was entered into the record during debate on the Senate floor. The letter was accompanied by 2 photos of the federal employee's new baby, and it stated, quote, "This is a picture of my son, Oliver. He was born on New Year's Eve, 10 weeks early. The only local hospital to take babies born before 32 weeks is not in the network for our insurance. I cannot change our insurance with this qualifying life event because those government services are closed due to the shutdown." I want to thank Senator Smith and also Representative Clark for bringing this issue to our attention. H.R. 2003 would ensure that employees who experience a qualifying life event, such as the birth or adoption of a child, could immediately enroll their dependents on a federal employee health benefits program plan, even if the government is shut down. The substitute amendment being considered would address technical comments provided by the Office of Personnel Management. It would make clear that the legislation covers changes made during an open season in the event a shutdown occurs during open season, and it would allow the processing of life insurance benefit transactions during shutdowns. The bill is supported by the American Federation of Government Employees, the National Active and Retired Federal Employees Association, and the International Federation of Professional and Technical Engineers. I urge my colleagues to join me in supporting H.R. 2003. I yield to the distinguished gentleman, ranking member, Mr. Jordan.
Thank you, Mr. Chairman, and I thought Mr. Meadows was going to be here for opening statement on both 2003 and 2004. I will just cut to the chase. We are fine with these 2 pieces of legislation. Appreciate your work, Representative Conley and Representative Meadows' work on both this bill and the one next in line in our on our agenda. And with that, we'd yield back and urge us to pass these.
Thank you very much. There being no further discussion on the amendments or the resolution, the question now occurs on the adoption of substitute amendment offered by the chairman. All those in favor signify by saying aye.
Aye.
All those opposed, nay. In the opinion, the ayes have it. The ayes have it, and the amendment is adopted. Question now.
Occurs on reporting it to the House. Just say this.
The question now is reporting it to the House floor. All those in favor signify by saying aye.
Aye.
And those opposed, the ayes have it. Thank you. Now, pursuant to notice, I call up 2004, H.R. 2004, ensuring the Fed, VIP, and the FLTCIP coverage during Shutdowns Act. The clerk will report the bill, which was distributed in advance.
H.R. 2004 to amend Title V United States Code to continue supplemental dental and vision benefits and long-term care insurance coverage for federal employees affected by the government shutdown and for other purposes.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes himself to offer an amendment in the nature of substitute. Copies of the amendment have already been distributed on the dais. The clerk will report.
Amendment in the nature of a substitute to H.R. 2004, offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered read and will serve as the base text for the purposes of amendment. I now recognize myself for 5 minutes. I want to thank my colleagues Jerry Connolly and Mark Meadows for joining me in introducing a bill that would mitigate some of the harmful effects of a government shutdown. During the recent shutdown, press reports indicated that federal employees might lose coverage for dental, vision, and long-term care insurance because coverage would continue only for 2 or 3 pay periods, after which insurers would start billing employees directly. H.R. 2004 would ensure that employees' dental and vision benefits and their long-term care insurance coverage would continue during any period the government is shut down. The substitute amendment addresses technical comments provided by the Office of Personnel Management. Among other things, the amendment would ensure coverage for individuals who've transitioned from the TRICARE program to the Federal Employee Dental and Vision Insurance Program. The bill is supported by the American Federation of Government Employees, the National Active and Retired Federal Employees Association, and the International Federation of Professional and Technical Engineers. I urge my colleagues to join me in supporting H.R. 2004. I yield now to the gentleman, the distinguished member of our, ranking member of our committee, Mr. Jordan.
Thank you, Mr. Chairman. We support this one as well. I yield back.
There being no further amendments, discussion on the amendments resolution, the question now occurs on the adoption of the substitute amendment offered by the chairman. All those in favor signify by saying aye. Aye. All those opposed signify by saying nay. In the opinion of the chair, the ayes have it. The ayes have it, and the amendment is adopted. The question now occurs on reporting it to the House floor. All those in favor of reporting to the House floor signify by saying aye. Those opposed, no. The ayes have it. Now, pursuant to notice, I call up H.R. 2530, the Interim Stay Authority to Protect Whistleblowers Act. The clerk will report the bill, which was distributed in advance.
H.R. 2530 to provide temporary authority to the General Counsel of the Merit Systems Protection Board to grant stays of personal actions and for other purposes.
Without objection, the bill is considered read and open to amend at any point. The chair recognizes himself to offer an amendment in the nature of substitute. Copies of the amendment have already been distributed and are on the desk. The clerk will report.
Amendment in the nature of a substitute to H.R. 2530 offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered read and will serve as the base text for purposes of amendment. I now recognize the distinguished chairman of our committee, Mr. Connolly, our subcommittee, Mr. Connolly, for 5 minutes.
Thank you, Mr. Chairman, and thank you for bringing this bill to our attention and to our consideration. The Merit System Protection Board is a small 200-person independent executive branch agency that seeks to protect the merit system principles of the federal government and our workforce, and it fosters a qualified, diverse federal workforce that's effectively managed and provides excellent service to the American people. However, since January 7th of 2017, the agency has been without a quorum, and the board has had 0 appointed members since March 1 of this year. This is the longest absence of a quorum in the history of the agency. And unlike other agencies, the vacant seats at the agency simply cannot be filled by an individual in an acting capacity. The last 2 years of vacancies have been unprecedented, and they've impaired the agency's mission. In February, the Subcommittee on Government Operations held its first hearing of the new Congress on this subject, the vacancy crisis at MSPB. We heard testimony that the absence of a quorum has prevented the board from hearing final appeals of adverse agency actions, such as terminations, suspensions in excess of 14 days, reductions in grade of pay, reductions in force actions, denials of restoration of reemployment rights, OPM determinations in retirement cases, and Hatch Act violations, among other things. The MSPB has also been unable to hear appeals of wrongful terminations and retaliations against whistleblowers. That means it's unable to enforce the law that this committee and the Congress on a bipartisan basis passed to protect those brave individuals who alert us to waste, fraud, and abuse. According to Tom Devine, the legal director of the Nonprofit Government Accountability Project, and one of our witnesses at that hearing, The current situation is disastrous for whistleblowers. The lack of a quorum has also resulted in a backlog of 1,975 cases produced, according to data produced to the subcommittee. Forming acting chairman Robbins reportedly said that eliminating that backlog will take at a minimum 3 years. That's a clear example of justice delayed, justice denied. This bill is a stopgap measure that addresses the most immediate threat to whistleblowers who report waste, fraud, and abuse and are subject to retaliation. In certain cases, the Office of the Special Counsel refers to the MSPP case in which they suspect an agency has taken unfair or adverse actions. In those cases, the MSPP can then stay or temporarily table the agency action while they adjudicate the claim. Without a quorum, however, the agency cannot execute or extend stays to prevent those unfair agency actions from going forward. This bill is a stopgap measure in the event of the lack of a quorum, and it would delegate the authority to stay agency actions to the general counsel of the agency. That delegated authority would expire immediately upon the appointment of even a single MSPB board member. The bill does not solve the problem of a lack of quorum, but it does provide support to employees who are trying to do the right thing. The bill keeps the lights on at an essential federal agency in times of crisis and would prevent agencies from taking retaliatory or prohibited personnel actions against those who disclose wrongdoing. This crisis was avoidable, and we hope to have board members in place as soon as possible. My colleagues who attended the meeting, including Mr. Meadows, will recall that this idea came out of a bipartisan sense, that we had a problem, not only at MSPB, but also at the lack of action by the Senate. And on a bipartisan basis, my friend will recall, we called upon the Senate to, in fact, at least approve the nomination of one of the president's appointees so we could have somebody who turned the lights on. I am pleased to say finally we have 3 full nominees. We do not yet have Senate confirmation. This is a stopgap measure. Hopefully it will never again be needed. But we got to protect whistleblowers. And as I said, this idea grew out of a bipartisan consensus on our board, and I hope the committee will take action, and I yield back.
Chair recognizes the distinguished member, Mr. Meadows.
Thank you, Mr. Chairman. I want to thank the gentleman and my friend from the 11th District of Virginia, Mr. Conley, for his leadership on this particular bill. Obviously, this is just interim authority, and candidly, the member is well-spoken and accurate in his analysis that we've got to get this fixed, and it's all about protection of whistleblowers. It's all about protecting the rights of those individuals that are truly willing to speak up, but not just that. It's making sure that those protections are there for our federal workforce, and there's no one that has been more diligent in that than the gentleman, Mr. Conley from Virginia, and I might add the gentleman from Virginia, Mr. Byers, as well. As you recall, he's not a member of this committee, but the 3 of us working together on this, and so I support this. But at the same time, I think it's important that we reiterate the Senate needs to get their job done. They take more naps than they do votes, and I'm at the point where I'm willing to call out both sides because they're not willing to do it. I did talk to the administration to make sure that we get enough of the nominees, and so with that, I would encourage my colleagues to support this bill, and I thank the gentleman for his leadership.
Would my friend yield?
Sure.
I want to thank him for his partnership and his leadership. He has shown a great deal of support for our federal employees, and I really thank him for that. I know he's taken the time out of his schedule to actually visit federal agencies and meet with groups of federal employees. Not many members take the time and trouble to do that, and I know it's appreciated. I also just wanted to remind him of his comments with respect to the Senate. Sam Rayburn, Speaker of the House, once said, in a different context, the Republicans are the opposition, but the Senate is the enemy.
And I would second that. I agree with the gentleman.
I yield back.
I yield back. Thank you, Mr. Chairman.
I want to thank my colleague, Jerry Connolly, and certainly Mr. Meadows. the Subcommittee on Government Operations for your leadership. And I want to just reiterate what Mr. Connolly just said. So often our federal employees are unseen, unnoticed, unappreciated, and unapplauded. And I want to thank both of these gentlemen for making sure that they keep them on the front burner, making sure that their rights are upheld, their benefits are intact, and protecting them. I think this is so very important. I have Social Security Administration in smack dab in the middle of my district, and I know that those many federal employees and many others really appreciate all that you've done. I'm pleased to be a co-sponsor with Ms. Connolly on H.R. 2530, the Interim State Authority to Protect Whistleblowers Act, is a measure that would ensure protection of federal government whistleblowers in the absence of any members of the Merit System Protection Board, which is the situation we are now facing. The holdover term for the last remaining board member, Mark Robbins, expired on March 1st. In February, the House passed legislation we introduced that would have extended Mr. Robbins' term, but the Senate failed to take action before his term expired. H.R. 2530 would give authority to the MSPB, the General Counsel, to issue stays in certain actions against whistleblowers in the event there are no board members. The General Counsel's authority would expire once one board member is nominated and confirmed by the Senate. The substitute amendment being considered would make minor technical amendments. I urge my colleagues to join in supporting H.R. 2530. All right. There being no further discussion on the amendments to the resolution, the question now occurs on the adoption of subsequent amendment offered by the chairman. All of those in favor signify by saying aye. All those opposed, nay. In the opinion, the ayes have it. It appears that the ayes do have it. The question now occurs on the reporting to the floor. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. The bill will be reported. I now pursuant to notice, I call up H.R. 1668, the Internet of Things Act. The clerk will report the bill which was distributed in advance. Before I go there, just one moment, Madam Clerk. Please, members, know that we will be voting at, I'll say, 4 o'clock. 4 o'clock. 4 o'clock. We will take all of it. How many votes do we have coming up?
7.
7, okay. We'll be taking all our votes at 7, and I'm sorry, at 4. At 4. It's been a long day. The clerk will read.
H.R. 1668, the leverage federal government procurement power to encourage increased cybersecurity for Internet of Things devices and other purposes.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes himself to offer an amendment in the nature of substitute. Copies of the amendment have already been distributed and are on the desk. The clerk will report.
Amendment in the nature of a substitute to H.R. 1668 offered by Ms. Kelly of Illinois.
Without objection, the amendment is considered read and will serve as the base text for the purposes of the amendment. I now recognize Ms. Kelly.
Thank you, Mr. Chairman, for including H.R. 1668, the Bipartisan IoT Cybersecurity Improvement Act, in today's markup. In 2017, the IT Subcommittee held a hearing on IoT cybersecurity following the October 2016 distributed denial of service, or DDoS, attack on domain name service provider Dyn, shut down internet access for millions on the East Coast. This attack was carried out by a botnet. In this case, the botnet was composed of hundreds of thousands of compromised, unsecured IoT devices. As such, there is a pressing need for the federal government to ensure its IoT devices are secure. While IoT devices can benefit employees and increase energy efficiency, the potential for harm cannot be overlooked. Many IoT devices today are built with almost no security at all. These devices can serve as gateways to accessing a network and launching cyber attacks. A recent AIR-D2 Global Connected Industries Cybersecurity Survey found that 8 in 10 organizations have experienced a cyber attack on their IoT devices in the past year. And this trend does not show any signs of going away. SonicWall recorded 32.7 million IoT attacks globally in 2018, a 217.5% increase over the 10.3 million IoT attacks logged in 2017. There is an urgent need for Congress to act now to ensure that unsafe devices are not added to federal networks. This bill instructs NIST to publish the final version of their 8,228 considerations for managing Internet of Things, IoT, cybersecurity, and privacy risk report taking into account at least secure development, identify management, patching, and configuration management. Then NIST will adopt their report for OMB to assist with creating agency-specific minimum security requirements. The Director of OMB, in consultation with the Director of the Cybersecurity and Infrastructure Security Agency of the Department of Homeland Security, will then promulgate standards for the procurement of federal devices to ensure that the government's IoT devices are kept up to date and not vulnerable to attack. NIST, in consultation with cybersecurity researchers and private industry experts, will publish guidance on creating a coordinated vulnerability disclosure program. Then OMB, GSA, and DHS will create standards for creating a CVD program to keep devices up to date. Contractors who do not comply with the CVD program will not be able to sell to the federal government except when an agency CIO determines that a covered device is necessary for national security or for research purposes. I would like to thank Congressman Hurd for leading the effort on the Republican side, as well as Chairman Connolly and Ranking Member Meadows of the Government Ops Committee for their continued work to strengthen federal cybersecurity. This committee has a history of approaching government technology on a bipartisan basis. I have worked cooperatively with the Oversight Majority and Minority Committee for months to make sure that this bill could pass on a bipartisan basis. This bill has 24 co-sponsors, 12 Republicans, and 12 Democrats. There is nothing partisan about this bill. This bill has strong outside support from CTIA, BSA, the Software Alliance, Verizon, Tenable, Cloudflare, and Symantec. I urge all members to support this bipartisan bill to secure government IT infrastructure and prevent agencies from wasting money on devices that make the government and the personal data of Americans less secure. Thank you, and I yield back.
Would you yield?
Yes, I will.
I thank my friend from Illinois. I just want to thank her for her leadership. She was the ranking member for the subcommittee in IT, and it was a privilege to work with her. She's shown great leadership in this area, and she's adding another bill to a string of bills in how the federal government both procures and manages IT. And I think that's very consequential. I think we're beginning really to make a difference, and I just want to thank Ms. Kelly for her leadership and her willing to cooperate on both sides of the aisle to make this happen. Thank you.
Very well. Mr. Jordan.
Thank you, Mr. Chairman. I, too, I got a couple concerns, but I do first want to thank Ms. Kelly and Mr. Hurd and Chairman Conley and Ranking Member Meadows and others on the work on this legislation. Ensuring our federal government cyber infrastructure is secure is obviously important. To that end, this bill seeks to put in place rules, standards that Internet-connected devices must meet before being acquired by federal agencies. While this is well-intentioned legislation, I do have, as I said, some concerns that I'd like to just put on the record if I could. First, the federal government already has standards in place related to cybersecurity. There's no reason to believe IoT devices would not be covered. I worry that this legislation would be redundant and could potentially create a patchwork of regulatory uncertainty. Second, the federal government buys a lot of stuff. As such, I fear that by focusing on setting standards for federal acquisitions of IoT technology, we would essentially be creating de facto regulations for the entire IoT sector. And this is important because Internet of Things devices are expected to add $11 trillion in value to the global economy in just the next 6 years. Makers of IoT devices know the importance of securing the devices they make. They know that making their products more secure will result in better products and give them a competitive advantage in the marketplace. It's all part of doing business. As I said, I think this bill is well-intentioned, but given the complexities of of the concerns I have. I had hoped we could have worked a little bit longer together to get this bill right. I don't plan on objecting, though, Mr. Chairman, and I thank you for your patience, and I yield back.
Thank you very much. I want to thank Representative Kelly and Hurd for introducing the bill before us, along with members from both sides of this committee. The bill would require the establishment of federal cybersecurity standards for devices connected to the Internet. I strongly support this bill. There being no further discussion or amendments to the resolution, the question now occurs on the adoption of the substitute amendment offered by Chairman. All those in favor shall signify by saying aye. Aye. All those opposed signify by saying nay.
Nay.
In opinion of the chair, the ayes have. The question now occurs on reporting it to the House. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
The bill appears that the ayes have it. The bill is reported to the House. Now, pursuant to notice, I call up H.R. 2978, a bill to reauthorize the National Historical Publications and Records Commission. The clerk will report the bill, which was distributed in advance.
H.R. 2978 to amend Title 44 United States Code to reauthorize the National Historical Publications and Records Commission and for other purposes.
Without objection, the bill is considered read and open to amendment. At any point, the chair recognizes himself to offer an amendment in the nature of substitute. Copies of the amendment have already been distributed and are on the dais. The clerk will report.
Amendment in the nature of a substitute to H.R. 2978 offered by Mr. Cummings of Maryland.
Without objection, the amendment is considered read and will serve as the base text for purposes of amendment. I now recognize the distinguished gentleman and the chair of our subcommittee, Mr. Connolly, for 5 minutes.
Thank you, Mr. Chairman, for taking up H.R. 2978, the National Historic Publications and Records Commission Reauthorization Act at today's business meeting. I'd also like to thank the ranking member of our subcommittee, Mr. Meadows, who is co-leading on the Republican side this bill. It would reauthorize the National Historic Publications and Records Commission for an additional 5 years at $15 million per year and add the Council of State Archivists as a member of the commission. The National Historic Publications and Records Commission was originally established by Congress back in 1934. Commission is a grant-making arm of the National Archives and Records Administration and provides grants to state governments and universities for activities to preserve, publish, and encourage the use of documentary sources relating to the history of the United States. It's made up of 15 members, including representatives of the 3 branches of the federal government, as well as professional archivists, historians, documentary editors, and records administrators. The Commission's small staff advises commissioners on grant proposals and provides advice and assistance to applicants. Authorization for the NHPRC expired at the end of 2009, nearly 10 years ago. For the majority of the fiscal years 1991 through that time, 2009, the Commission's authorization was set at $10 million a year. Since the most recent authorization expired, Congress has continued to appropriate approximately $6 million per year for the Commission. However, that amount has not been adequate to support ongoing programs and keep up with the demand for digitized records. Many institutions have vast paper archives which require extensive staff time to index and scan to create more accessible digital archives. This is part of the important preservation mission of the NHPRC, but due to a lack of funding, the NHPRC is only able to award a fraction of the grant applications it receives. For example, in 2017, it received more than 100 grant applications for archival records grants and was able to award only 20 of the 100. In 2018, about 95 grant applications were submitted, and again, fewer than 20 were awarded. And I might add, Mr. Chairman, I've got the records of a number of our members in their respective states, and just to pick one, Ohio, it's several hundreds of thousands of dollars with 60 projects funded by this organization, and that's just one state. All of our respective states have benefited from this very modest but very important program. These grants are awarded across the entire country, with a majority going to colleges and universities. Funding also goes to state and local governments, museums, historical societies, and eligible nonprofits, and lastly, recognized Native tribes and recognized groups. The majority of these grants require 50% cost sharing. Without some federal funding, many of these communities would be unable to preserve their important local histories. Grants from NHPRC have funded projects such as the Papers of George Washington, the Papers of Thomas Jefferson, the Papers of Alexander Hamilton. Half of its funding has traditionally been provided to such publication projects. These projects are now being created online, and older projects are being converted to digital formats, but that costs money. That takes investment. With the help of these grants, our constituents do not need to visit the National Archives here in Washington to view the actual papers of our nation's founding fathers. Rather, they can go online anywhere and now view the papers of a famous Republican Ohio senator, for example, Robert Taft, from their comfortable living room at home or their local library, thanks to the funding grants this organization has provided. The failure of Congress to keep the authorization current has contributed to a strain in resources, as might be imagined. The $10 million annual authorization in 1991 would be equivalent to $19 million today when factoring in inflation. Reauthorizing the Commission at $15 million sends a clear message that Congress supports the Commission's ongoing efforts to preserve important documents in our nation's history and bring them online so that taxpayers can have easy access to treasured historical documents, as well as those of local resources that are so vitally important to local history. I am delighted to have bipartisan support with my friend and ranking member, Mr. Meadows, in the subcommittee, and I would hope the committee would support this very modest bill, but with a big impact on all of our respective districts and states. And I yield back.
Mr. Jordan.
Thank you, Mr. Chairman. Notwithstanding all the nice things the chairman of the subcommittee had to say about projects being done in the great state of Ohio, I do think it's important to point out that this commission has been funded at $6 million, and this legislation would more than double that and take it to 15. Maybe we could just do what the House Appropriations Committee thought we should do and take it just to 7. Again, that's not Republicans making that decision. That's the Democrats on the House Appropriations Committee saying 7's enough to keep doing the good work they're doing, including that great work they're doing in the state of Ohio. Let's just go with that. So I have real concerns about that much of an increase in this important commission. No one's saying it's not, but it's been functioning at $6 million. The appropriators want to take it to 7. That should probably be good enough. Not more than doubling it and taking it to 15. So, Mr. Chairman, I'm opposed to the amount. If you want to do an amendment, 7, be happy to do that, and so we could get everyone to support it, I think. But I have concerns and would respectfully oppose the legislation. I yield back.
Mr. Chairman, I think it's really important to note what I said and repeated. The reason funding has been straight-lined at 6 is because the program wasn't reauthorized. Had it been reauthorized, it certainly would have been at least at 10 million, but I pointed out that with inflation, it actually would be 19. So it's not a doubling of anything. And this is a very modest amount of money that all of us benefit from. We're talking about preserving our history. And oh, by the way, what the appropriators do is what they do. We are authorizers. We can authorize to a certain limit, and if the appropriators want to appropriate less, that's certainly their prerogative. And they do it sometimes. Sometimes they even go right up to the authorization. I want to make sure that this is reauthorized, and it's reauthorized at a level that gives us some flexibility. And the final point I'd make, Mr. Chairman, is we're getting ready for the 250th anniversary, which means there will be an uptick in this kind of activity. And the demand and resources will grow, not diminish. And I think we should be prepared for it. This is a very modest bill with with a very modest uptick in funding. I urge the committee to adopt the full $15 million, and I'm delighted to see my friend from North Carolina, who is an original co-sponsor of this. This is a bipartisan effort. I would be happy to hear from him. I yield back, Mr. Chairman.
Are you yielding to the gentleman from North Carolina?
I'm happy to yield to my friend from North Carolina.
Seems to be happy to talk.
I have no idea what the gentleman from Virginia is talking about because I.
But you agree with it.
But I agree 100%, and with that, I offer support and I yield back.
Oh, I love it. Okay. Thank you very much. There being no further discussion on the amendments to the resolution, the question now occurs on the adoption of the substitute amendment offered by the chairman. All those in favor shall signify by saying aye. All those opposed shall signify by saying nay. In the opinion of the chair, the ayes have it. The ayes have it, and the amendment is adopted. The question now occurs on reporting the bills to the House floor. All those in favor signify by saying aye. Aye. All those opposed, no.
No.
The bill appears to have been, the ayes have it. We'll report to the House floor.
I would record a vote on that one.
Want a recorded vote on that one, Madam Clerk? All right. Last but not least, now pursuant to notice, I call up the following postal naming bills, which were distributed in advance. H.R. 1250, H.R. 1526, H.R. 1833, H.R. 1844, H.R. 2451, H.R. 2325, H.R. 3144, H.R. 3152. That's it. Without objection, the bills considered as read, and I would request unanimous consent for their immediate consideration en bloc. Without objection, the bills are passed.
We will recess for 5 minutes and resume. We will resume and take votes at 4 p.m.
Again, we will be taking votes at 4 o'clock. That's in 6 minutes.
I'm going to add that last vote to this list, and I'll get you a butterfly clip. This is going to be your vote script with one more added, which I will take up with that. We'll stand in a brief recess.
We will stand in a brief recess until 4 o'clock. Are we starting here? Come on.
We're going to resume the voting votes, just to say.
We will now, I think we have a series of 8 votes. Is that right, Madam Clerk? 8?
I have 9.
9? 9. We will resume our markup session by voting on those 9 questions. The question now occurs on the Heiss Amendment, which failed by voice vote. The yeas and nays are ordered. The clerk shall call the roll on the Heiss Amendment.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney?
No.
Ms. Maloney votes no. Ms. Norton?
No.
Ms. Norton votes no. Mr. Clay? Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper? Mr. Connolly? Mr. Krishnamurthy? No. Mr. Krishnamurthy votes no. Mr. Raskin? Mr. Raskin votes no. Mr. Ruda? No. Mr. Ruda votes no. Ms. Hill? Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Welch? Mr. Welch votes no. Ms. Spear? Ms. Spear votes no. Ms. Kelly? Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Khanna? No. Mr. Khanna votes no. Mr. Gomez? No. Mr. Gomez votes no. Ms. Ocasio-Cortez? No. Ms. Ocasio-Cortez votes no. Ms. Presley? No. Ms. Presley votes no. Ms. Tlaib? No. Ms. Tlaib votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Amash? No. Mr. Amash votes no. Mr. Gosar? Yes. Mr. Gosar votes yes. Ms. Fox? Yes. Ms. Fox votes yes. Mr. Massey? Yes. Mr. Massey votes yes. Mr. Meadows? Yes. Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Yes. Mr. Grothman votes yes. Mr. Comer? Yes. Mr. Comer votes yes. Mr. Cloud? Yes. Mr. Cloud votes yes. Mr. Gibbs? Yes. Mr. Gibbs votes yes. Mr. Higgins? Yes. Mr. Higgins votes yes. Mr. Norman? Mr. Norman votes yes. Mr. Roy? Ms. Miller? Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
Mr. Chairman, how am I recorded?
Mr. Cooper is not recorded.
How am I recorded?
No.
Mr. Sarbanes is not recorded.
No.
Mr. Sarbanes votes no.
Mr. Welch?
Mr. Cooper, you voted no. Mr. Cooper votes no. Mr. Connolly is not recorded. Mr. Connolly votes no.
Ms. Kelly?
Mr. Clay? Mr. Clay votes no.
How's Ms. Kelly recorded?
Ms. Kelly is not recorded. Ms. Kelly votes no.
Is anyone else wishing to vote?
On this vote, we have
Ballot.
15 yeas, 24 noes.
Amendment fails. Our next the question now occurs on the Higgins amendment, which failed by voice vote. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney?
No.
Ms. Maloney votes no. Ms. Norton?
No.
Ms. Norton votes no. Mr. Clay? Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper? No. Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? No. Mr. Krishnamurthy votes no. Mr. Raskin? No. Mr. Raskin votes no. Mr. Ruda? No. Mr. Ruda votes no. Ms. Hill? Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Sarbanes votes no. Mr. Welch? Mr. Welch votes no. Ms. Spear? Ms. Spear votes no. Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes no. Ms. Pleskett? Ms. Pleskett votes no. Mr. Khanna? Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes no. Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes no. Mr. Gosar? Mr. Gosar votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Mr. Grothman votes yes. Mr. Comer? Mr. Comer votes yes. Mr. Cloud? Mr. Cloud votes yes. Mr. Gibbs? Mr. Gibbs votes yes. Mr. Higgins? Mr. Higgins votes yes. Mr. Norman? Mr. Norman votes yes. Mr. Roy? Ms. Miller? Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
How's Mr. Clay recorded?
Mr. Clay is not recorded. Mr. Clay votes no.
Is everyone who wishes to vote has voted? Clerk shall give the tally, please.
On this vote, we have 15 yeas and 24 noes.
Noes have it, the amendment fails. The question now occurs on the Norman amendment, which failed by voice vote. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney?
No.
Ms. Maloney votes no. Ms. Norton?
No.
Ms. Norton votes no. Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Lynch votes no. Mr. Cooper? Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? Mr. Krishnamurthy votes no. Mr. Raskin? Mr. Raskin votes no. Mr. Ruda? Mr. Ruda votes no. Ms. Hill? Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Sarbanes votes no. Mr. Welch? Mr. Welch votes no. Ms. Spear? Ms. Spear votes no. Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes no. Ms. Pleskett? Ms. Pleskett votes no. Mr. Khanna? Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes no. Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows. Mr. Meadows votes yes. Mr. Heiss. Mr. Heiss votes yes. Mr. Grothman. Mr. Grothman votes yes. Mr. Comer. Mr. Comer votes yes. Mr. Cloud. Mr. Cloud votes yes. Mr. Gibbs. Mr. Gibbs votes yes. Mr. Higgins. Mr. Higgins votes yes. Ms. Norman. Mr. Norman votes yes. Mr. Roy. Ms. Miller. Ms. Miller votes yes. Mr. Green. Mr. Armstrong. Mr. Armstrong votes yes. Mr. Stubbe. Mr. Stubbe votes yes.
Anyone else wishes to vote? Clerk will give the challenge.
On this vote, we have 16 yeas and 23 noes.
Amendment fails. Question now occurs on the Cummings Amendment, which passed by voice vote. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
Yes.
Mr. Cummings votes yes. Ms. Maloney? Yes. Ms. Maloney votes yes. Ms. Norton? Yes. Ms. Norton votes yes. Mr. Clay? Yes. Mr. Clay votes yes. Mr. Lynch? Yes. Mr. Lynch votes yes. Mr. Cooper? Yes. Mr. Cooper votes yes. Mr. Connolly?
Yay.
Mr. Connolly votes yes. Mr. Krishnamurthy? Yes. Mr. Krishnamurthy votes yes. Mr. Raskin? Aye. Mr. Raskin votes yes. Mr. Ruda? Yes. Mr. Ruda votes yes. Ms. Hill? Ms. Hill votes yes. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes yes. Mr. Sarbanes? Mr. Sarbanes votes yes. Mr. Welch? Mr. Welch votes yes. Ms. Spear? Ms. Spear votes yes. Ms. Kelly? Ms. Kelly votes yes. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes yes. Ms. Plaskett? Ms. Plaskett votes yes. Mr. Khanna? Mr. Khanna votes yes. Mr. Gomez? Mr. Gomez votes yes. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes yes. Ms. Presley? Ms. Presley votes yes. Ms. Tlaib? Ms. Tlaib votes yes. Mr. Jordan? Mr. Jordan votes no. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes no. Ms. Fox? Ms. Fox votes no. Mr. Massey? Mr. Massey votes no. Mr. Meadows? Mr. Meadows votes no. Mr. Heiss? Mr. Heiss votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Comer? Mr. Comer votes no. Mr. Cloud? Mr. Cloud votes no. Mr. Gibbs? Mr. Gibbs votes no. Mr. Higgins? Mr. Higgins votes no. Mr. Norman? Mr. Norman votes no. Mr. Roy? Ms. Miller? Ms. Miller votes no. Mr. Green? Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Mr. Chairman,
Yes.
I'd ask that my vote be changed from yay to aye. Thank you.
Is there anybody who's not voted? Anybody wish to change their vote? Madam Clerk, you may give the challenge.
On this vote, we have 24 yeas and 15 noes.
The amendment is adopted. The question now occurs on the Meadows Amendment, which failed by voice vote. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? No. Ms. Maloney votes no. Ms. Norton? No. Ms. Norton votes no. Mr. Clay? No. Mr. Clay votes no. Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper? No. Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? Mr. Krishnamurthy votes no. Mr. Raskin?
Nay.
Mr. Raskin votes no. Mr. Ruda? Mr. Ruda? Mr. Ruda votes no. Ms. Hill? Ms. Hill votes no. Ms. Wasserman Schultz. Ms. Wasserman Schultz votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. Welch. Ms. Spear. Ms. Spear votes no. Ms. Kelly. Ms. Kelly votes no. Mr. DeSaulnier. Ms. Lawrence. Ms. Lawrence votes no. Ms. Plaskett. Ms. Plaskett votes no. Mr. Khanna. Mr. Khanna votes no. Mr. Gomez. Mr. Gomez votes no. Ms. Ocasio-Cortez. Ms. Ocasio-Cortez votes no. Ms. Presley. Ms. Presley votes no. Ms. Tlaib. Ms. Tlaib votes no. Mr. Jordan. Mr. Jordan votes yes. Mr. Amash. Mr. Amash votes no. Mr. Gosar. Mr. Gosar votes no. Yes. Ms. Fox. Ms. Fox votes yes. Mr. Massey. Mr. Massey votes yes. Mr. Meadows. Mr. Meadows votes yes. Mr. Heiss. Mr. Heiss votes yes. Mr. Grothman. Mr. Grothman votes yes. Mr. Comer. Mr. Comer votes yes. Mr. Cloud. Mr. Cloud votes yes. Mr. Gibbs. Mr. Gibbs votes yes. Mr. Higgins. Mr. Higgins votes yes. Mr. Norman. Mr. Norman votes yes. Mr. Roy. Ms. Miller. Ms. Miller votes yes. Mr. Green. Mr. Armstrong. Mr. Armstrong votes yes. Mr. Stube. Mr. Stube votes yes. Mr. Welch is not recorded. Mr. Welch votes no.
Has everyone voted? Does anyone wish to change the vote? The clerk should give us the tally now.
On this vote, we have 15 yeas and 24 noes.
The amendment by the distinguished gentleman from North Carolina fails. We will now go to the question now occurs on the Gibbs amendment, which failed by voice vote. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? Ms. Maloney votes no. Ms. Norton? Ms. Norton votes no. Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Lynch votes no. Mr. Cooper? Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? Mr. Krishnamurthy votes no. Mr. Raskin? Mr. Raskin votes no. Mr. Ruda? Mr. Ruda votes no. Ms. Hill? Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Sarbanes votes no. Mr. Welch? Mr. Welch votes no. Ms. Spear? Ms. Spear votes no. Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Khanna? Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes no. Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes no. Mr. Gosar? Mr. Gosar votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Mr. Grothman votes yes. Mr. Comer? Mr. Comer votes yes. Mr. Cloud? Mr. Cloud votes yes. Mr. Gibbs? Mr. Gibbs votes yes. Mr. Higgins? Mr. Higgins votes yes. Mr. Norman? Mr. Norman votes yes. Mr. Roy? Ms. Miller? Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stube? Mr. Stube votes yes.
Has everyone voted? Does anyone wish to change the vote? Madam Clerk? Clerk, please give us the tally.
On this vote, we have 15 yeas and 24 noes.
The amendment is not adopted. The question now occurs on the Comer Amendment, which failed by voice vote. Yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? No. Ms. Maloney votes no. Ms. Norton? No. Ms. Norton votes no. Mr. Clay? No. Mr. Clay votes no. Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper? No. Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy?
Nay.
Mr. Krishnamurthy votes no. Mr. Raskin? Nay. Mr. Raskin votes no. Mr. Ruda? Mr. Ruda votes no. Ms. Hill? No. Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? No. Mr. Sarbanes votes no. Mr. Welch? Mr. Welch votes no. Ms. Spear? No. Ms. Spear votes no. Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Khanna? Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes no. Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes no. Mr. Gosar? Mr. Gosar votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Mr. Grothman votes yes. Mr. Comer? Mr. Comer votes yes. Mr. Cloud? Mr. Cloud votes yes. Mr. Gibbs? Mr. Gibbs votes yes. Mr. Higgins? Mr. Higgins votes yes. Mr. Norman? Mr. Norman votes yes. Mr. Roy? Ms. Miller? Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stube? Mr. Stube votes yes.
Has everyone voted? Does anyone wish to change their vote? Madam Clerk, please give us the tally.
On this vote, we have 15 yeas and 24 noes.
The noes have it. The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute, which passed by voice vote. The yeas and nays are ordered. The clerk shall take the call.
Mr. Cummings?
A point of order. I'm assuming that we're,
Voice, yeah.
as amended,
You want to do this voice?
but this is an amendment in the nature of a substitute as amended?
Yes.
He asked for
Okay.
after we voiced, so we can do voice on this. Yeah, and then,
You're just going to do one vote? You're going to do one vote?
Yeah,
Is that it?
okay. So you're making your request for the roll call? No,
Just one,
report on-
just one vote, he said, okay?
Okay.
Question now occurs on reporting the report to the House, which is put de novo. The yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
Yes.
Mr. Cummings votes yes. Ms. Maloney?
Yes.
Ms. Maloney votes yes. Mr. Norton? Ms. Norton? Ms. Norton votes yes. Mr. Clay? Mr. Lynch? Mr. Lynch votes yes. Mr. Cooper? Mr. Cooper votes yes. Mr. Connolly?
Aye.
Mr. Connolly votes yes. Mr. Krishnamurthy? Mr. Krishnamurthy votes yes. Mr. Raskin? Mr. Raskin votes yes. Mr. Ruda? Mr. Ruda votes yes. Ms. Hill? Ms. Hill votes yes. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes yes. Mr. Sarbanes? Mr. Sarbanes votes yes. Mr. Welch? Mr. Welch votes yes. Ms. Spear? Ms. Spear votes yes. Ms. Kelly? Ms. Kelly votes yes. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes yes. Ms. Plaskett? Ms. Plaskett votes yes. Mr. Khanna? Mr. Khanna votes yes. Mr. Gomez? Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes yes. Ms. Presley? Ms. Presley votes yes. Ms. Tlaib? Ms. Tlaib votes yes. Mr. Jordan? Mr. Jordan votes no. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes no. Ms. Fox? Ms. Fox votes no. Mr. Massey? Mr. Massey votes no. Mr. Meadows? Mr. Meadows votes no. Mr. Heiss? Mr. Heiss votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Comer? Mr. Comer votes no. Mr. Cloud? Mr. Cloud votes no. Mr. Gibbs? Mr. Gibbs votes no. Mr. Higgins? Mr. Higgins votes no. Mr. Norman? Mr. Norman votes no. Mr. Roy? Ms. Miller? Ms. Miller votes no. Mr. Green? Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no. Mr. Gomez, you're not recorded. Mr. Gomez votes yes. You are not recorded, Mr. Clay. Mr. Clay votes yes.
Has everybody voted? Anyone wish to change their vote? The clerk shall give us the tally.
On this vote, we have 24 yeas and 15 noes.
Pursuant to this vote, the Committee on Oversight and Reform hereby adopts this report recommending that the Attorney General William Barr and Commerce Secretary Wilbur Ross be held in contempt of the Congress of the United States of America for defying duly authorized subpoenas from this committee and refusing to produce documents required by those subpoenas relating to the 2020 census. We will move the report to the full House. On this vote, the motion to reconsider is laid upon the table. Staff is authorized to make any technical and conforming changes. There being no further business.
Are we saying unanimous consent that the motion to reconsider is laid upon the table?
Yes.
Well, I object.
You go ahead.
Chairman, request time to file additional views?
Yes, of course.
Your mic.
I'm sorry, the mic is on. The yeas and nays are ordered. Clerk should call the roll.
Mr. Cummings?
Yay.
Mr. Cummings votes yes. Ms. Maloney?
Aye.
Ms. Maloney votes yes. Ms. Norton? Ms. Norton votes yes. Mr. Clay? Mr. Clay votes yes. Mr. Lynch? Mr. Lynch votes yes. Mr. Cooper? Mr. Cooper votes yes. Mr. Connolly?
Aye.
Mr. Connolly votes yes. Mr. Krishnamurthy? Mr. Krishnamurthy votes yes. Mr. Raskin? Mr. Raskin votes yes. Mr. Ruda? Mr. Ruda votes yes. Ms. Hill? Ms. Hill votes yes. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes yes. Mr. Sarbanes? Mr. Sarbanes votes yes. Mr. Welch? Mr. Welch votes yes. Ms. Spear? Ms. Spear votes yes. Ms. Kelly? Ms. Kelly votes yes. Mr. DeSaulnier? Ms. Lawrence? Ms. Lawrence votes yes. Ms. Plaskett? Ms. Plaskett votes yes. Mr. Khanna? Mr. Khanna votes yes. Mr. Gomez? Mr. Gomez votes yes. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes yes. Ms. Presley? Ms. Presley votes yes. Ms. Tlaib? Ms. Tlaib votes yes. Mr. Jordan? Mr. Jordan votes no. Mr. Amash? Mr. Amash votes no. Mr. Gosar? Mr. Gosar votes no. Ms. Fox? Ms. Fox votes no. Mr. Massey? Mr. Massey votes no. Mr. Meadows? Mr. Meadows votes no. Mr. Heiss? Mr. Heiss votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Comer? Mr. Comer votes no. Mr. Cloud? Mr. Cloud votes no. Mr. Gibbs? Mr. Gibbs votes no. Mr. Higgins? Mr. Higgins votes no. Mr. Norman? Mr. Norman votes no. Mr. Roy? Ms. Miller? Ms. Miller votes no. Mr. Green? Mr. Armstrong? Mr. Armstrong votes no. Mr. Stube? Mr. Stube votes no.
Has everyone recorded their vote? Is anyone wish to change their vote? The clerk will give us the tally.
On this vote, we have 23 yeas and 16 noes.
The bill passes. Moving forward.
Mr. Meadows objected to the motion to lay the,
To reconsider on the table. So
and therefore we need to have a recorded vote.
Yes,
On what?
On the motion.
on the table,
Tabling the motion to
reconsider.
We will have a vote on the delaying on the motion to table on the motion to reconsider.
Mr. Meadows objected.
Mr. Meadows objected.
Do you still,
Are you still objecting, Mr. Meadows? I know you want to stay here for a while, but are you still objecting?
we did not mean to blow past you.
We didn't mean to blow past you.
I know, and in this,
yeah.
you know, you were so close to voting for my amendment.
Yeah,
Just so doggone close.
I was on the one inch line.
I know, and boy, if I could have just pushed you across.
Yeah, I just couldn't.
I will withdraw my
Thank
objection
you
on the
very
motion
much.
to reconsider.
I appreciate that. Wait,
And I hope the gentleman reconsiders next time when I offer a very thoughtful amendment.
Well, all your amendments are thoughtful. Amen.
We will
Will
when
be.
we will when it's a thoughtful amendment.
We're waiting.
Then thank him,
The-
and then say
Thank you
this is-
very much. I really appreciate it.
Then say this is the last vote.
The last, but this is the last vote, ladies and gentlemen.
Thanks to Mr. Meadows.
Thank you, thank you very much, Mr. Meadows. The question now occurs on favorably reporting H.R. 2978 as amended to the House, which is put the no vote, the yeas and nays are ordered. The clerk shall call the roll.
Mr. Cummings?
Yes.
Mr. Cummings votes yes. Ms. Maloney? Yes. Ms. Maloney votes yes. Ms. Norton? Yes. Ms. Norton votes yes. Mr. Clay? Yes. Mr. Clay votes yes. Mr. Lynch? Yes. Mr. Lynch votes yes. Mr. Cooper? Mr. Connolly?
Aye.
Mr. Connolly votes yes. Mr. Krishnamurthy?
Aye.
Mr. Krishnamurthy votes yes. Mr. Raskin?
Aye.
Mr. Raskin votes yes. Mr. Ruda? Mr. Ruda votes yes. Ms. Hill? Ms. Hill votes yes. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes yes. Mr. Sarbanes? Mr. Sarbanes votes yes. Mr. Welch? Mr. Welch votes yes. Ms. Spear? Ms. Spear votes yes. Ms. Kelly? Ms. Kelly votes yes. Mr. Desanye? Ms. Lawrence?
Ms. Lawrence?
I can coach
Ms.
you.
Lawrence votes yes. Ms. Plaskett? Ms. Plaskett votes yes. Mr. Khanna? Mr. Khanna votes yes. Mr. Gomez? Mr. Gomez votes yes. Ms. Ocasio-Cortez? Ms. Ocasio-Cortez votes yes. Ms. Presley? Ms. Presley votes yes. Ms. Tlaib? Ms. Tlaib votes yes. Mr. Cooper, you're not recorded. Mr. Cooper votes yes. Mr. Jordan? Mr. Jordan votes no. Mr. Amash? Mr. Amash votes no. Mr. Gosar? Mr. Gosar votes no. Ms. Fox? Ms. Fox votes no. Mr. Massey? Mr. Massey votes no. Mr. Meadows? Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Comer? Mr. Cloud? Mr. Cloud votes no. Mr. Gibbs? Mr. Gibbs votes no. Mr. Higgins? Mr. Higgins votes no. Mr. Norman? Mr. Norman votes no. Mr. Roy? Ms. Miller? Ms. Miller votes no. Mr. Green? Mr. Armstrong? Mr. Armstrong votes no. Mr. Stube? Mr. Stube votes no.
Has everybody voted? Anyone wish to change their vote? That's it? Huh? Is that it? Is there anything else I need to say? The clerk will give us the tally.
On this vote, we have 24 yeas and 14 noes.
That, the bill will be reported to the floor. With that, ladies and gentlemen, we are at the end of our markup, and I want you to take a moment to thank all of you. This was a very difficult moment, but I think we handled it extremely well. And I think that everybody on both sides fully treated this moment with the respect that it deserves. And it's a very, very important thing that we've done, and I think we're sending a message that we simply want our democracy to stay intact. Staff will make